Please, Lordship. Lord.
Yes.
If it is otherwise not inconvenient to your Lordship, my Lord, can the item number 6 be taken up in the second half of the 2?
Item number
6, my Lord.
6. Okay.
Take
Taken
your
up.
Lordship.
I beg to mention item number 21, my lord. In this matter, my lord, on the last occasion, my lord, the lordship was pleased to direct the state respondents to apprise this honorable court whether the inquiry report has been communicated to the petitioner or not, my lord. So can it be taken up at 2, my lord?
Oh, yeah, Mr. T. Nath appeared.
Yes, my lord. He was for the college authorities, my lord, and the instruction direction was issued to K. Gogoi, my lord.
We'll take it up too.
My lord, I am
May it
obliged.
please your Lordship, I beg to mention for listing of an interlocutory application for imprisonment of the Treasury Officer, Lordship, in WPC 7560.
Your matter is there.
No, Lordship, for listing on 19, Lordship. So, Lordship fixed the matter on 27, but Treasury Officer is an necessary party, so it filed an interlocutory application. So, Lordship, kindly fix the matter on 19.
We'll have it on 27. Don't worry. These matters, I don't require interlocutory applications. I do it by myself. You filed it very well. Good for you.
Lordship,
Have it on
yes,
27th
provisional-
only.
Lordship, provisional pension has been sanctioned by the respondent authority, but Treasury Officer has not taken any steps, initiated any steps, and Lordship received some amount already sanctioned by
Okay.
the.
We'll have it on. You then bring by way of an additional affidavit that aspect also. The provisional pension, you have got it. Bring that aspect by way of an affidavit. Huh? So we'll have it on 21st. 21st. 2-1.
Lordship fixed the matter on 27 on earlier occasion.
27th is a Thursday. Why I have fixed it on 27th?
It is already.
Anyway,
filed,
we'll have it
Lordship,
on 21st.
for obliged.
I have a prayer in regards to the item number 21 of today's list.
Yes.
Lordship, respondent has carved us a copy of additional affidavit today.
Hmm.
Can it be taken up of 27 of this?
You are?
I am for the petitioner. I am appearing on behalf of Senior Counsel KP Pat.
Lordship, we have
Oh,
filed a
that matter.
Yes,
Lordship.
Lordship.
Viswanchali
Pertaining
municipal.
to whether you have not got you something, no?
Yes, sir. Taking a regular scale of pay, Lord.
Yeah.
Lordship, we have filed a affidavit today saying that as per the Lordship direction, that saying that the petitioners will be giving the regular salary forthwith and the earlier salary will be considered by the board.
So, why do you need it for an adjournment? That I have only directed on that day. He had stated that. Then I have said that let it be put on by way of an affidavit.
As instructed by my senior.
Mr. Counsel, kindly don't make such submissions before this court. How can a senior counsel instruct you? Tell me. You have to instruct the senior counsel. That is the manner in which the things work. Isn't your senior counsel the senior designated counsel? Can he instruct? We'll take it up.
Lordship, this requisition may be allowed.
Yes.
Like,
Item number 1 from Moson.
It is a lordship. In this case, petitioner is put his honorable court for non-payment of salary to the petitioner after his service has been regularized.
Oh, matter, no notice has been issued for
No-
last
no
so many
notice,
years.
lordship. Due to date.
You filed it on 13th of October. Maybe because of the date.
No, lordship. Actually, on
Yeah.
earlier occasion, the court asked me to made an inquiry that after the service has been regularized.
Tell me what do you want, madam?
Notice to be issued. Lordship.
Notice that I will issue. What do you want? What is your case?
Cases for
Due
non-payment
to
of
the
salary.
REA and other service, the petitioner is entitled to get his service from his, for his service as so and so from the date of appointment and also in terms with the order dated past by so and so. What do you want?
Uh,
Entitled for what?
salary, Lordship,
Salary
salary and
from?
other allowances. After my service has been regularized, Lordship.
Regularized when?
28/2005 annexed, Lordship.
So 28, 2005.
Yes, I'm still working.
You were earlier working as?
I was on irregularly appointed. Subsequently, order dated 9/8/2005. Number of 2776 teachers services were regularized, were irregularly appointed
Excess.
in excess. Yes, Lordship. Thereafter, 190.
Now you want the earlier salary from the date of your appointment.
or from the date of my regularization. Lordship.
Date of the regulation makes sense.
Notice can go ahead.
Huh?
Notice has not been issued. Notice can go ahead.
So all these years, what have you been doing? You have got your instructions? No? See, without notice, they don't work. But Miss S. Dasgupta, the learned counsel appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the respondent number 1,
One,
2,
two,
4,
four,
5,
5 and
and
6.
6. Mr. A. Soliha appears for the respondent number 2, 3. Issue notice making it returnable on 17th of May, 2023. As the respondents are duly represented by their respective counsels, extra copies of the writ petition be served upon them by
I can serve it today. Sir.
12th, tomorrow. By 12/4/2023. The case of the petitioner herein is that the petitioner had not received his or her
Yes, Lordship.
his salary from 28 2005, whereby the petitioner's service was regularized. And what is the name of the petitioner?
Hilaluddin Lashkar.
Where I will find his name in that order of 28
36, serial number 36, Lordship.
of page number,
Page
87,
number
Lordship.
50, Lordship. 50.
page number 50.
That additional affidavit.
Serial number 36, Lordship.
The service was regularized. And the petitioner was appointed at Lakshminagar Tribal ME School. The respondent, more particularly the respondent number 1, 2, 4, 5, and 6 shall apprise this court on the returnable date as to why the petitioner's salary have not been paid pursuant to the order of regularization dated 28/2005.
I just
I know two.
Make leisure lawsuits. This is
Yes,
the
madam.
non-payment, yes, non-payment of salaries, madam. School was provincialized in the year 2021.
Oh, I asked you to file an additional
Yeah, affidavit,
affidavit.
yes, madam. Affidavit along with the repetition, madam.
Yes, representation.
Page 19, affidavit.
Hey, no.
They got salaries only in the month of August, my lord. After August, they did not get the salaries, madam.
From August 2021 till today, you have not received
Nothing.
your salary.
Yes,
Which department?
education department.
Yes.
That's secondary department.
Why?
Item 2.
The petitioner was regularized on the basis of this order
Yes, my,
dated 4/1/2021.
for January 2021. Annexure 1.
Have you joined?
Joined, and we have been paid in the month of August, my lord.
Only 1 month.
Only 1 month.
So you have
This
not got
instant
from the
date
month of
is-
September.
Yes. That is my case.
Let me issue short notice. Let me issue short notice.
Tomorrow?
Not tomorrow, madam.
We'll have it on 8th of May.
Yes, ma'am.
Yes.
Ms. K. Devi, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf. Oh, what is the?
All
code?
the respondents, madam. 1, 2, and 3.
Wait. Madam,
Yes,
there are 4 petitioners. Why only 1 court fee?
my lord.
Why only 1 court fee of 60 rupees?
Then I will pay, my lord. I don't know,
No.
because earlier also this provision is going.
The court is very strict on that aspect.
I'll pay.
Because if you want, you can, I give you the liberty of choosing one of the petitioners whom,
No,
in
my lord,
whose
I'll
favor
pay.
you want the order to be passed.
I'll pay.
Ms. K. Devi, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatonia appears on behalf of the respondent number
1, 2, and 3, madam.
1, 2, and 3. Issue notice making it returnable on 8th of May 2023. As the respondent is duly represented by Mr. N.J. Khatonia, extra copies of the petition be served upon him by 12/4/2023. The case of the petitioner herein is that the petitioner were appointed as
School, actually school was provincialized, my lord. So Surjit Das is a.
They were provincial under 2017 Act, my lord.
Yes, my lord.
that the case of the petitioner is that the petitioner, the services of the petitioner were provincialized
Which effect from 1st August 2020.
in Bongaigaon Vidya Mandir High School with effect from 1st of August 2021. However, the petitioner always tutors
Yes,
Yes, madam. Tutors.
tutor.
as tutors.
Yes,
The services of the petitioners were provincialized as tutors with effect at Bongaigaon Tikon Vidya Mandir High School with effect from 1st of August 2021. Thereupon, the petitioners received the salary for the month of August 2021. However, with effect from 1st of September 2000, from the month of September 2021 till date, the petitioners have not received their salary. Being aggrieved, the petitioners have submitted a representation on 14/2/2023 before the Inspector of Schools BTC Bongaigaon. However, nothing has been done. It is under such circumstances the instant writ petition has been filed. The respondents hearing are directed to apprise this court on the next returnable date as to why the salary of the petitioners have not been paid, and as to and shall also apprise as to when the said salary would be paid. Pusto. Liberty is given to the petitioner to mention the matter for update.
Oblige, Lordship.
Note 3,
Fair play, Your Lordship.
My lord, petitioner is agree by non-consideration of her representation, that is page number 16.
What?
My lord, petitioner is the legally married wife of the private respondent, and as a married wife, my lord, she made a representation to the divisional forest officer Dhubri for inclusion of her name as a nominee in the service record, my lord, of her husband.
What?
But that has not been done. My lord. Page number 16, 116, my lord.
You are not staying with your husband?
I stayed, but presently, my lord, one maintenance case is going on since I have not been maintained, my lord, for some time. So ultimately, after retirement of my husband, my lord, since my marriage took place in 2018 and retirement took place in 19, my lord. So ultimately, at the time of retirement, my name was not included in this as a nominee, my lord.
And your husband has no other wife?
No other wife.
And he married at the age of 59.
59. Because my earlier wife died, my lord. Then I was married.
Yes, Mr. Hassan.
Well, there is a marriage covenant, that is annexure 1, my lord, that your lordship will find page 11, and one maintenance order is also there, that is page number 13, my lord, FT criminal case passed by the learned, my lord, family court Dhubri, my lord.
What is it? Register A under 6 and 7. What is this?
It is, my lord, Muslim marriage, my lord, before the Qazi, my lord, before the
So
Muslim marriage,
this marriage took place in 2018
18, my lord.
and he retired when?
I retired in 19, my lord.
19 when? Where is your representation submitted to the authority?
Yes, my lord, that is page number 16, my lord.
16.
Page number 16, my lord.
Huh?
It was, my lord, submitted on 19th of September to 2022. my lord.
But you say that you are not living presently with your husband. Isn't this contrary to what have you stated out there in your representation?
Yes, my lord. After marriage, my lord, both live together as husband and wife. But sometime, my lord, for the time, a dispute took place between them, and ultimately, my lord, she was not maintained by her husband.
When did the dispute take place?
So ultimately, my lord, husband, my lord, ultimately for some time, my lord, did not stay with her. So ultimately, she had to file one maintenance case also.
When did you file the maintenance case?
And that maintenance case, my lord,
In 2019.
yes, my lord.
And asking for what?
Asking for, my lord,
That you want to be maintained as you are living separately.
yes.
And then why did you write in your representation that you are living together happily?
So ultimately, my lord, as a wife, my lord, ultimately, even after this maintenance order was also passed, my lord, ultimately, since
Ultimately, what ultimately?
separation did not take place between them, ultimately, their marriage is subsisting and their husband and wife. Their marriage is subsisting, my lord.
Heard Mr.
MS.
M.A. Islam, the learned counsel appearing on behalf of petitioner. Mr. S.M. Hassan appears on behalf of the respondent number 1, 3. Mr. A. Chakraborty appears for respondent number 2. Issue notice making it returnable on 19th of May 2023. As the respondent number 1, 2, and 3 are duly represented, extra copies of the writ petition be served upon him by 12th of April 2023. As regards the respondent number 4, steps be taken by way of registered as well as usual by 12/4/2023. The case of the petitioner herein is that the petitioner is the sole wife of the respondent number 4. The petitioner married the respondent number 4 on
my lord,
8/4/2018. However, in spite of submitting a representation, the respondent authorities have not included her name as one of the nominees to receive the family pension on behalf of one of the nominees of the respondent number 4. The respondent shall apprise this court on the returnable date as to why the petitioner's name has not been included within the definition of family as a nominee in the service book of the petitioner of the respondent number 4.
And now 4.
Yes, Mr. Counsel.
My lordship, the grievance of the petitioner in the present petition is that he has not been paid the arrear salary during his suspension period. My lordship, he got suspended on 5/10/2018.
Area salary during suspension period.
Yeah, during his suspension allowance. He was
You
suspended. My
didn't get your subsistence allowance?
My lordship, he has not been paid his salary during his suspension period.
Okay.
He was suspended on 5/10/2018.
Where's your order of suspension?
My lordship, it is on page 5, para 3.
Page 5. Huh? Order of suspension.
My lordship, page number 17.
17. Yes, pending trial of Kaya of so is hereby placed under suspension with immediate effect. 5th of October 2018. Then
Yes, my lordship. Then he prayed twice before the
you are
respondent.
still under suspension?
No, your lordship, he was reinstated. His reinstated order dated is 2nd July. It is on page 25.
Department of Proceedings for- So the period of suspension shall be treated as a period on duty,
Yes, your lordship.
and as such, you will be entitled for this particular salary
Yes, your lordship.
during this
After
period.
this lordship,
Did you receive any subsistence allowance?
no, he have not received yet anything. So for this reason, my lordship, he had paid twice to the respondent authority, and after receiving his prayer letter, the respondent authority has mentioned all the details of the payment. My lordship may kindly see page 28 to 30, 28, 29, 30. After receiving his prayer letter.
You didn't get a single penny.
No, your lordship. The petitioner haven't got it. Then,
Mr.
then lordship, he also paid
Enough. What is your name?
My lord, we'll take
AR
instructions.
Mehdi.
We'll take instructions, my lord.
A.R. Mehdi.
AR Mehdi.
Mr. A.R. Mehdi, the learned counsel appearing on behalf of the petitioner. Mr.
R.B. Goswami, my lord.
R.D. Goswami.
B.B.
R.P. Goswami appears on behalf of the respondent numbers
respondents.
1, 2, 5. Issue notice making it returnable on 17th of May 2023. As the respondents are duly represented by the learned counsel, extra copies of the writ petition be served upon him by 12/4/2023. The case of the petitioner herein is that the petitioner was put under suspension by an order dated 5/10/2018. Pending 5/12 to 5/10/2018. Pending broil of departmental proceedings. Thereupon, by an order dated 2/7/2022, the departmental proceedings were brought to a close. Whereby a penalty has been imposed upon the petitioner. However, in the said order dated 22nd of July 2022, it has been specifically mentioned that the period of suspension shall be treated as on duty for all purposes. It is the case of a petitioner that the petitioner was neither paid any salary nor subsistence allowance during this period of suspension. Claiming the said amount, the petitioners have approached the respondent authorities. However, till date, nothing has been done to ventilate the grievances of the petitioner, for which the instant writ petition has been filed. The respondents are directed to apprise this court on the next returnable date as to why the petitioner have not been paid the salary during the period of subsistence, even after the order dated 22 order dated 2nd of July 2022, specifically holding that the period of suspension shall be treated as a period as on duty. The respondent shall also apprise this court on the returnable date as to when the said amount shall be paid to the petitioner. Liberty is given to the petitioner to mention the matter for arbitration.
Supplemental list, item number 75 for motion.
Yes, Mr. Rafiq.
Matter relates to transfer matter. The petitioner before a lawsuit is an employee of railway department. Is an employee of railway department.
Hey, এটা যে আছে KDV কেছটো আছিল না আপুনি লৈছিল না, taking into account that the amount that the 4 petitioners and the court fee of only 1 petitioner have been paid. And the same being pointed out to the learned counsel, Ms. KDV. The learned counsel have submitted that she will take necessary steps on or before the returnable date for payment of the deficit. Yes, tell me.
By an order dated 13/10/2022, my lord, has been transferred in violation of the guideline of the railway board. Now, thereafter, my lord, immediately he approached the respondent number 3 and intimated.
You have been transferred?
Yes, my lord.
From
Bongaigaon to North Lakhimpur.
Bongaigaon to North Lakhimpur.
And my wife is an assistant.
Why you can't be transferred? Is your
On
post
admission.
not transferable? Is your post not transferable?
Transferable, yeah.
Now tell me why you shouldn't be transferred?
Your lordship, kindly see page 14 close B, para D.
14 years. Tell me.
where one of the spouses is a railway servant and the other belongs to state service. The railway servant should be posted at the station place in the railway division PU in whose territorial jurisdiction the place state of posting of his her spouse falls. If it is not possible, if a request from the railway servant to the controlling authority of the spouse for his her posting at the place of posting of the railway servant is received, the same may be forwarded to the concerned authority for sympathetic consideration. Now,
Now,
you have to kindly say annexed
for how long you are there at which place you are there?
Bongaigaon.
Bongaigaon. For how long you have been there?
I was posted there in the year 2020.
2000? 3 years.
Yes.
Now you have to go to North Lakhimpur. Prior to that, where were you?
Prior to that, in another office of under Bongaigaon.
Oh, then you are still in Bongaigaon only.
Yes.
Then
Because my only fear is that it violates the guideline. Although I don't have any.
yeah, it is
statutory
may
report,
be
yes.
considered
But you'll have to kindly say my
if it is
represent-
not possible.
if it is not possible. But
Then
they are silent about it.
so
My representation is still pending. You'll have to kindly see my representation. Annexure
annexure,
3, page 70.
yeah. What is NBQ?
New NBQ New Bongaigaon.
Oh, New Bongaigaon. It's a section from 2005 you are there.
Not on that post, different post. Yes, ma'am.
Same station.
2005, I was posted as a CMI at New Bongaigaon.
Have been transferred and posted at AR with headquarters at NBQ. 2012, myself posted at NBQ. In the year 2000, I was posted at Bongaigaon with the jurisdiction of again in the year I have been transferred and posted at NBQ with section. I can show you. Yes, madam.
Lordship, he is in the Bongaigaon since long and only on spouse ground. She is a teacher and she will always have to stay in the Bongaigaon. So on this ground only.
You have joined that posting at
No,
last.
no.
Well,
And
then
posting order, transfer
join
order is
there
of 1310.
and then they will consider whatever may be.
No.
Because why should this court interfere?
And it is only Lakhimpur, Lordship, not so far.
This memorandum has been
Madam, you are from North Lakhimpur.
No.
Otherwise, it takes 8 hours from here.
Lordship.
Otherwise, it takes 8 hours from Guwahati to reach Lakhimpur.
The transferable
And
job,
another
Lordship.
4 hours from there, 12 hours. Yes.
Hello, kindly see the why this memorandum has been framed. It is written in like that. In view of utmost importance attached to the enhancement of women status in all walks of life and to enable them to lead a normal family life, as also to ensure the education and welfare of children. That's why it is framed.
That means you can only be there at Bongaigaon.
Yes.
You cannot go anywhere else because your wife is always going to be at Bongaigaon.
Is it-
So your condition of service is violated.
Look, if it is impossible, they can inform me for certain,
Huh?
for this or that reason, it is not possible to keep me here. But it seems that the impugn order has been passed in violation of the guide.
So
So, my lord,
this is
although-
not mandatory.
Yes, my lord, although I don't have any statutory report, but it is take.
They will consider.
Yeah,
I
my
will
lord,
only
let-
say that they
Yes,
will
ma'am.
consider representation, but I'm not touching anything on this.
Yes, my lord, let them consider my.
But you join there.
My lord, if
You
I-
join there because that is the law. One has to join out there to that particular place and thereafter you submit your representation. This order was passed on 18/3. We are almost a month. You have not joined.
No,
And
my
at the
lord, this-
fag end of the,
13
just before the
13
Bihu vacation, you have come before
No,
this.
my lord,
Transfer order is of 1310.
As per the 13
Huh?
2000,
1310 Lordship.
1310.
Yes,
Yes.
Lordship. 6 months have passed.
thereafter I approached the respondent number 3 to consider my case, my lord. He kept the matter pending.
Transfer order is of 1310.
Yes, my lord.
1310.
No disciplinary action has been
Nothing, my
taken.
lord, because
And you are still joining. You are still working out
Yes.
there. How is it possible? Madam?
Lordship.
How is it? How is a person possible? That means the transfer order has been stayed. Then why are you approaching this court?
I have approached the respondent number 3, my lord, to consider my case in view of the memorandum. He kept the matter pending.
In March, he has submitted.
You
his-
submitted your representation on 18th of March,
18 March.
and then you have approached here in the month of April. Why?
My lord, I have stated, initially I have approached the respondent number 3.
Where is your representation?
You have to kindly see page 6, para 6.
Huh?
Page 6.
No,
para-
no, no. No representation business. This court is not interfering with this.
Initially, I
I dismiss the petition. Whole day, morning, there's been no dismissal. This is the first dismissal of the day. Yes.
one more annexure may I bring your lord.
Yes,
Knowledge
tell
letter.
me.
Last annexure is 19.
No, no. Yes, Office of the Honorable Minister for a number of representatives has been received from me for last year, wherein request for transfer on house funds have either been denied or acting for activity. For the enhancement of women's status in all walks of life to enable them to lead a normal family life. Therefore, that all such requests should be examined on prior a position indicating status of all such pending here. What is the date of this communication?
My lord,
18/8/2022. So good. Why you are not giving it to the minister? Why you are approaching this court? The minister may help you a lot. See, you see, can you say this 18/8 gives you an enforceable right?
just to show my lord that how they can keep the matter pending.
So let them do it. Put it to the minister also, give a copy to the minister, railway minister. Then look here, this is what is being done. Give it to the chairman and CEO, railway board. That this is what he is doing. We have only given to the senior divisional commercial manager, NF Railway, Rongia.
Yes.
Why will not given to the general manager? Give it to them and bring them. Have you brought on record this thing? Why you have not brought on record these aspects of the matter in your representation of 18/8/2022?
Subsequently, I have received it.
You received later on.
I-
Then, if you have received later on, better you give that representation. Withdraw. File your representation out there or dismiss. Which one?
Withdraw.
File your representation with all these documents. Because these are not enforceable in a court of law. Heard, Mr. I, Rafiq, the learned counsel for the petitioner, Miss
RDB.
RTP. appears on behalf of the respondent
All right,
railway
Your Honor, please
authorities. The learned counsel for the petitioner has submitted that though in the representation dated 18/3/2023, there has been, the petitioner had taken the ground of spousal, the ground, the spouse ground as one of the reasons for not affecting the transfer order dated 13/10/2022. However, in the said representation, the file notings dated 18/8/2022 issued from the office of the Minister of State for Railways have not been brought to the attention of the respondent authorities. He therefore submits that he may be permitted to withdraw the instant writ petition. He further submits that the withdrawal of the writ petition should not affect his right to submit a fresh representation to the authorities, bringing to the notice of the authorities about the file notings dated 18/8/2022 issued from the office of the Honorable Minister Office of the Minister of the State for Railways (J). Taking into account this submission, the instant writ petition stands dismissed on withdrawal. However, the petitioner would be at liberty to file such representation before the concerned authority, and the authority shall, in its wisdom, take into consideration the said representation and dispose of the same. And dispose of.
All right.
Item number 5, part third for admission.
Mr. Mehdi, you have filed your additional affidavit doing something. Where is the additional affidavit? It has not come on record.
It has not come to me.
No, it has not come.
Now. Yes, page 147,
The last, huh?
page 147, 140, 149.
Understood.
This is the.
But here we are having only till 145, 146.
Well, may I show you the
So what? That day I was dictating your judgment. Halfway I had to leave it on account of nothing is there in your petition that you are willing to give up the EPFO? No? Yes. Pension as for the EPFO and take into account the other one. Mr. Mehdi will take it up on 20. Let the affidavit be on record. No, who was taking the dictation on that day? Somebody was taking. I think Prem was taking. Just asking.
My lord was always already halfway through, my lord.
Yes. Halfway through, then I saw in the petition there was nothing to that effect. And where is the Madras High Court judgment here?
My lord has got a printout of that.
I got it, I know that, but where is it? Oh, yeah, got it. Hello. Heard Mr. PCR Methi, the learned counsel for the petitioner. Mr. R. Dubey appears on behalf of the Airport Authority of India. Mr. M.K. Majumdar appears on behalf of the Employees Provident Fund Organization. And Mr. A.R. Tabildar appears on behalf of the central government. There's no on behalf. Then I'll put it none appears for the central government on call. Okay. Mr. PCR Mehdi, the learned counsel appearing on behalf of the petitioner, had submitted that he had already filed an affidavit in terms with the order dated 28/3/2023. The registry is directed to bring on record the said affidavit so filed by the petitioner to list the matter on 24/2023 for further consideration.
7,
Yes, Mr. Avidin, it's an old matter.
Yes, my lord.
Last order passed on 7/9/92,
Yes, my lord.
22. What are you asking for?
My lord, I'm asking for my salary, and over here, my lord, what happens, they have, I was appointed, then I was regularized, then I was sent for junior basic training. Then there was the reason for the government to give me show cause along with 752 people, saying that we were appointed against non-existent post, and there was a legal battle before this honorable court at one point of time regarding that illegal appointees, and after that, in view of this High Court's order, they have taken up a screening of these all illegal appointees, and it seems they have sorted out 4 categories of people, and they filed an affidavit. The commissioner himself filed an affidavit saying that out of the 4 categories, they have clarified 1 category, that is the regular legal appointment.
4 or 3?
4.
Okay. What are the 4?
One is
Not recommended and discontinued. That was not recommended and discontinued. They were neither.
One was illegal.
Hmm.
One is irregular. One was legal.
legal.
What is the 4th?
4th was
illegal and they no longer remain in service.
Understood. So there are 3 only, as far as I know. Where the 4th one come?
now 4th. The divisional screening committee categorized the following categories and numbers in these 4: recommended and working till date. Recommended but discontinued the service.
Recommended but discontinued.
Discontinued.
Very well.
Not recommended but working till date.
Right.
Not recommended
And
and
discontinued.
discontinued the service.
They were neither recommended.
Now, who is that person? What committee is
Not
this?
so simple, my friend.
What committee is this?
This is the screening committee, divisional screening committee, which was formed by the government in order to see all these appointments which were doubtful in throughout the state.
And what is this Monoharan committee?
That is much earlier.
That is another committee.
That is another one.
This is another committee
This is another one.
headed by.
This was, my lord, this started because of this, there was a direction from this honorable court. Go for the screening of all these persons who has claimed their appointment and asking for the salary. Ultimately, because of the High Court's, in view of the High Court's order.
So you got your salary till February 2012.
Yes, sir.
After February, you have not got.
No.
Because you have been categorized as.
I am not recommended but working till date. And my lord, would your lordship be pleased?
Are these government schools?
Yes, sir.
How are you working?
My lord, the thing is that my initial appointment was against a existent post,
Hmm.
existent vacancy.
Hmm.
Then, my lord, I was, in fact, I was regularized
Hmm.
against an existing vacancy.
Where is your order of regularization?
My lord, this order of regularization,
95.
95, 7695, page 21.
Yeah. Why you were regularized against another post when you are appointed against another post?
My lord, sometimes this, what I understand,
Hmm.
sometimes this regularization takes place when there is a permanent retained post. Suppose I'm appointed.
So
against
you were not appointed against a permanent retained post.
retained post.
So
But it
your
was a-
initial appointment was
It
not
was a-
proper.
against a vacancy. No, my lord, these posts which are not permanently retained.
Now, just for
Because-
example, a person A was appointed in a school. No vacancy, nothing, business. Just appointed. Then he vacates. Person B is being appointed. But there's no post. Vacant post, sanctioned post of the government. Would you say that his appointment would be the proper appointment? B?
My lord, the present scenario of the government, I can't give this answer directly because there is when the stipendary appointments are made.
No. Whatever may be, there is a fact-finding inquiry wherein it found that your appointment which was there was not to a sanctioned post. But the question is, you have been regularized to a sanctioned post. Now, prior to this appointment which is being done, if the appointment has not been done in terms with Rule 3 of the 77 rules, by finding out how many vacancies are there, and thereafter a selection committee appointment is being made. If it is not done in that manner,
Then it cannot be termed as legal appointment.
now can there be a subsequent regularization being done by the government, irrespective of the mandate of Rule 3 not being complied with?
What my lord is asking as a query, then answer would be should not.
Hmm?
Should not. But over here,
So the regularization,
no, but this, these things.
while
go on.
regularizing somebody, if a person is not appointed against a sanctioned post, a regularization is being done. What is this concept of a regularization in under the provisions of 77 Act or the 74 Act or the 77 rules?
My lord,
Is
over-
there a concept of regularization?
my lord, over here,
Ah,
as far as this petitioner is concerned, the regularization is also gone. Because subsequent when they have taken this entire scenario of the screening committee and the verification of all the documents and everything.
Hmm.
So I was categorized.
Hmm.
I was categorized in the third one, my lord.
Third one, which one? Where is that order you are asking for? This one.
My lord, this is the,
You are challenging this Annexure 12,
yes, my lord,
topping of salaries of 752 terminated teachers.
yes, my lord,
Now, where is their regularization? They have filed an affidavit, na?
yes, they filed an affidavit.
Where they have mentioned about this.
My lord, have you got- my lord,
The petitioner belongs to the post group of 752 terminated teachers of Dhemaji and Lakhimpur district.
my lord, which paragraph?
Here, the cases of Dhemaji or Lakhimpur.
Dhemaji stroke
The
Lakhimpur was-
petitioner is from Dhemaji or Lakhimpur?
Dhemaji.
Dhemaji. Very good. Dhemaji. Yes, Dhemaji. Total number of applicants 733, not recommended, but working till date is 640. Not recommended and discontinued is 93. Very well. Is that the position of 752 plus 14 numbers of illegal Dhemaji is also similarly placed as in the case of the category 3, category of 3,000. Not recommended, but working till. Now serving in the school of Hebrew. You were appointed in 89.
Yes,
Then how are you working now at Dibrugarh?
I was transferred.
By the authorities.
Yes, yes, by the authorities. After that initial regularization,
Hmm.
I was transferred in the year 2001,
Hmm.
and then I was in Dibrugarh.
Hmm.
I was receiving my salary. And then suddenly this,
Now, have you brought him within the ambit of this decision which you took, the cabinet decision of 7/10/2021?
Lordship.
He has been brought in.
Yeah, Lordship, he has been brought in this, that cabinet decision, and he was not recommended, not accepted by, approved by the government.
why?
Lordship, as per the available materials on record, he was not approved by the, my instruction is he was not approved by the government.
Why?
He was amongst those illegal teachers, Lord. 752 plus 8470, those illegal teachers who were brought under the purview of this cabinet decision, and subsequently scrutiny committee and some of them were approved by the government. They're those who received salary to a certain period of time as well as underwent training. They were approved as a teacher. Those who received salary to a certain point of time up to.
But he also went through training.
Lordship, these are all illegal.
Salary up to
appointments, Lordship.
2008, but I received up to 2012. That was the benchmark they have set.
Because the-
Whether training completed and received salary up to 2008. I've
Now, Mr.
completed,
Abedin, is your case improving to the case of taking into account the 2021 that you have not been taken into account in the 2021 also?
no, they have not taken me,
No, are you agreed with that?
2021.
Huh?
Yes, my lord, anything. For survival.
But you know what is the impact of a 2021 taking? They have stated out there in the orders of appointment that you forego all your rights in respect to the earlier one.
But my lord, over here, I don't understand only one thing, because if your lordship looks at their own affidavit, which is none other than the commissioner himself filed it,
Hmm.
saying that the category which is 8,470,
Hmm.
among that, they have categorized and they have taken the decision in the following manner, that is paragraph 15, page 8 of this affidavit.
Hmm.
So, well, successful completion of junior basic training, which is equivalent to DLED, that is one criteria, and receive salary up to 2007.
Where you are reading?
This is page 8 of the affidavit, my lord.
Page 8.
Yes, my lord.
Yes,
My lord, paragraph 15,
15.
this is the entire picture they have summed up. And now,
No, just read paragraph 14 also.
yes, my lord.
13.
Paragraph 13,
Yeah.
in fact, one line from the thing,
Paragraph 13, read it. That in compliance to this court's order dated 2/3/2010, the government had taken a decision and passed a speaking order on 13/7/2018 with a direction to the director to issue individual show cause to the illegally appointed teachers of 8470 numbered teachers, along with 752 numbers and 14 numbers of terminated teachers of Dhemaji. Did you get the term show cause?
No.
Huh?
No.
Why have you not filed a reply?
Which one, my lord?
This one against this, you have filed reply?
This show cause?
No,
No, no, they have to.
this affidavit,
No, because this was in my favor. Because
understood. Why
when the-
you are not stating that?
no, what I'm saying, when the paragraph 15 comes,
Para 13,
paragraph 13, my lord, this is one aspect of the matter, my lord.
Huh.
Actually, they have said that 752, they have given the termination letter. In that, my lord, earlier round of litigation, it was proved that none of the petitioners, none of those 752 received any kind of a termination letter.
but then
Ultimately,
also in 2018, there was a decision.
my writ petition is 2016.
Understood, but
I did not get
2018 is a decision.
I did not get that decision. This is not incorporated in the reply.
Understood, Mr. Abedin. Why are you not putting it by way of a reply? Am I to take what you are saying or say what the
I
petitioner says?
understand, my lord.
You get the point?
Yes, I understand.
Then only the things will be there, then I can,
Yes. I got it, man.
you get it.
But would your
Now,
lordship
let
please-
us see paragraph 14
Okay.
further.
That the deponent states that as per finding of the hearing report, the 752 plus 14 numbers of teachers were appointed against non-existent posts. Therefore, government is not in a position to pay salary to these illegal teachers found now after completion of the inquiry, as it is a settled position that illegal appointees do not have any enforceable legal right in service, including claim of salary. However, the government is still considering their cases to resolve the issues. Now the page, paragraph 15. That in the meantime, a discussion was held between the Honorable Minister and the Teachers Association in respect of the aforesaid 8,470 numbers of illegally appointed teachers and 752 and 14 teachers on 7/9/2018 to resolve the issue. As per the decision of the meeting, the department has proposed to take a decision to solve the problem of these illegally appointed teachers, subject to approval of cabinet by observing the following parameters. My lord, A, the teachers who have fulfilled the educational qualification as on date of according to the NCT norms. B, the teachers who have submitted the following genuine documents related to drawal of salary at some point of time after they receive successful, my lord, B, I come in, my lord, successful completion of basic training course, which is equivalent to DLED examination, then possession of GPF account, but that I have now. Thereafter, the subcommittee was constituted to verify the particulars of the teachers which have in the meantime prepared 3 lists. Number 1, the teachers who have received salaries up to 2007 and onward and having JBT or DLED. I fall in this category.
Mr. Sharma, tell me one thing.
Lordship.
Whom have you regularized? By the cabinet decision, whom have you regularized in 2021?
2021, following the cabinet decision, Lordship.
Yes. Whom have you regularized? You, the term used is illegal or irregular.
Lordship.
You have regularized.
Lordship.
Why not the petitioner? What is the yardstick by which the petitioner have been thrown out?
The yardstick was, Lordship, it is specifically mentioned here, the teachers who have received salary up to 2007,
He received till 2012.
Lordship, that is the.
Understood.
These are illegal teachers, Lordship. Now that is
Understood. I
subject to
understand, but
verification.
why have you regularized this illegal?
As per materials available, it was found that the category, the
Mr.
yardstick
Sharma,
was-
there is no quarrel with the proposition that the regularization is absolutely within the domain of the government.
Lordship.
But while affecting the scheme of regularization, if there is a pick and choose,
There was no pick and choose, Lordship.
then why have you put the petition outside?
The contention of the petitioner of whether.
We do one
Otherwise-
thing, we have it after vacation, you bring this aspect of the matter in by way of an affidavit. We can deal with it. Because and deal with these, that you have all these things by way of an affidavit, which are given in paragraph number 15.
These are in my writ petition.
Understood that you have drawn all this salary and all these things are
yes.
there and you have not received your so cause and
Yes.
develop your thing that in respect to this also. I will bring this thing on record by putting it as an Annexure X. Do you develop your case?
Yes, sir.
Yes. And Mr. Sharma, you also put by this, put by way of an affidavit.
Lordship.
What is the basis on which you have
Lordship.
appointed those people into? Yes, the cabinet has taken a decision. Very well, the cabinet has the power to take a decision.
Lordship.
One time. The term which is being used out there in the appointment orders
Lordship.
is illegal oblique irregular.
Lordship.
If it is illegal and irregular,
These are illegal, Lordship.
understood, but your appointment orders also categorically say that those people who are
Lordship.
illegal oblique irregular,
Lordship.
they have been appointed
Lordship. Lordship.
pursuant to a decision on 7/10/2021.
21.
Then,
20.
yes, whatever may be.
Lordship.
And they have been given appointed on 31/2021.
On two category based on some criteria.
Yes, criteria. You bring out that on
Lordship.
records.
Lordship.
Heard Mr. Ite Abidin, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the Education Department.
Elementary.
And Mr. R. Babudari appears for the Finance Department. Finance is there?
Finance is there.
Yes or no?
Respond number 2.
Very well. Appears for the Finance Department. The learned counsel appearing on behalf of the Education Department had submitted on instructions. They submitted an instruction dated on the basis of an instruction dated 10/4/2023. Wherein and given by the Director of Elementary Education, wherein it has been mentioned that the petitioner, Srimati Deepika Doloi, was not approved for by the government for accommodation in pursuance to the meeting, in pursuance to the cabinet resolution taken on 7/10/2020. There is, however, no reasons assigned as to why the petitioner case was not approved by the government for accommodation. The said set of instructions is kept on record and marked with the letter X. The petitioner would be at liberty to take a copy of the said document, certified copy from the record. You can give him, yeah, not the letter X. The Director of Elementary Education is directed to file an affidavit as to what is the basis on which the petitioner was not approved by the government for accommodation in pursuance to the cabinet's decision dated 7/10/2020. Mr. J. Abidin further submit, learned counsel for the petitioner submits that he would also like to file an affidavit in reply to the affidavit in opposition. Taking into account the state, let the matter be listed on 24th of May, 2023.
Would your lordship be pleased to mention only one thing, my lord?
Yes,
I received over there because as they are giving the affidavit, my submission was that I completed JBT training 2021.
understood, but whatever it is, you file your reply.
No, I understand. Okay.
Item 8.
You see, you are filing the reply in 2023. Bring that aspect of the matter that you have not been considered there. Don't make me,
Only one thing, my lord. I think
don't make me argue for you
I understand.
any further.
I got it, my lord.
Yes,
Only
you
thing,
got it to
as
now
per-
further develop it.
My lord,
Yes. Yes,
They
Mr.
should-
Saikia.
They should have had the time bound for filing the affidavit so that I could have filed the reply before that day, my lord.
Not necessary. Let them file the affidavit, you file your reply. That document is already there. I've already recorded in the order also. So you know what is to be done.
If you have-
Hmm. Yes, Mr. Saikia. Oh, yes.
It is your lordship.
What is your case?
Matter pertains to conversion of pension from old pension scheme to the new pension scheme, your lordship.
You are what?
I was initially appointed as assistant teacher, lordship. Two petitioners, one petitioner was appointed in the year 94, lordship, and the other petitioner in the year 93, lordship.
Purely
Petition number.
temporary basis subject to satisfaction.
Afterwards, our
Then-
services were regularized in the year 2005, lordship. And the year
Then what
2000
happened?
in the year
Following
2000
teachers who were regularized by were allowed to join against the vacant post of the schools below as so and so. Your name is what?
Haitun
Haitun Bhuiya.
Bhuiya, lordship.
Very well. Then
And petitioner number 2 is,
this happened in 2005.
yes, lordship. We were
Regularized on 25/8/2005.
lordship.
Then
Thereafter, lordship, PF accounts were allotted to us.
where you come under the excess teachers?
Access teacher.
Huh?
Access teacher.
Excess?
Access teacher.
Then what is your claim petition? Old pension, new pension.
Old pension.
You are
new
covered.
Lordship, old pension, we are covered by the old pension, lordship, because we were initially appointed in the year 94 and 93, lordship. And
Understood. But whether your sister, you were found to be in excess, whether you were appointed against the sanction post, you must have heard what I was telling Mr. Abedin.
it was against a vacant post, your lordship.
Eh?
Or else we would have not got the salary, lordship.
You didn't get your salary from 1996 onwards.
Yes, 95 onwards.
Yes. 95 onwards. You excess. So it is covered by the judgment.
Lordship.
Heard, Mr.
MR
M.
Chaudhary.
So and so the learned counsel appearing on behalf of the petitioner. Mr. Ian Sharma appears on behalf of
1, 2, 3, and 4, Lordship.
petitioners, appears on behalf of respondent number 1, 2, 3, and 4. Miss,
On behalf of
your name,
Tinlo.
so and so. Give your name in the list. Appears on behalf of the Accountant General AE. The case of the petitioner herein is that the petitioner initially was appointed by the district elementary education officer on 7/19 petitioner. When were you appointed? All are different dates.
Petitioner number 1, lordship, 7/1/1994.
The petitioners herein were appointed on the following dates by the district elementary education officer. The petitioner number 1 will be by an order dated. What is the number?
7/1/90, annexure 1, page 14, lordship.
Petitioner
7/1/1994.
number 1's name is Haitun Bhuiya.
Haitun Bhuiya.
The case of the petitioners herein is that the petitioner number 1 was appointed by the district elementary education officer on 7/1/1994. And the petitioner number 2 was appointed also by the district elementary education officer Kamrup on 26/11/1993. Thereupon, the petitioners got their salary, joined their respective schools and got their salaries. Later on, it was found that the appointment, the subsequent to 1995, the petitioners have not received their salaries. In the meantime, the respondent state had taken steps for inquiry. No. In the meantime, subsequent thereto, on the basis of a report being submitted by one Mr. Manoharan, IAS, by committee comprised under the chairmanship of Mr. Manoharan, IAS, which is commonly known as the Manoharan Committee. It was found that the petitioners were appointed in excess of their sanction post. The government of Assam thereafter took a decision to regularize the services of those teachers who were appointed in excess of the sanction post. The petitioners herein were appointed, the services of the petitioner herein were regularized by an order dated
29/2005.
11/8/2005. Against vacant post. Subsequent thereto, the said, subsequent to the order dated 11/8/2005, issued by the Director of Elementary Education, the District Elementary Education Officer Kamruk have issued orders dated 28/2005 and 29/2005 respectively, in continuation to the order dated 11/8/2005. The case of the petitioners herein is that the petitioners are entitled to pension in terms with the Assam Service Pension Rules 1969, and the case would not be covered under the new defined contributory pension scheme 2009, which came into effect from 1/2/2005. The Learned Counsel, appearing on behalf of the School Education Department, Mr. P.N. Sharma, has drawn the attention of this court to the recent judgment in the case of Purnima Kaur versus State of Assam, WPC number 6413/2021, 22, something, dated 31/3/2023, wherein this court, by a detailed judgment, have held that the excess teachers have held that those teachers who fell within the category of excess teachers and whose services were regularized after 1/2/2005 would not be entitled to the benefit of the old pension scheme under the Assam, covered by the provisions of the Assam Service Pension Rules 1969. as well as also would not be entitled to subscribe to the General Provident Fund. It was, however, mentioned that those persons, those teachers would be only entitled to the new contributory, new defined contributory pension scheme 2009, which came into effect from 1/2/2005. Taking into account the said judgment dated 31/3/2023 in Purnima Hor Supra, which squarely covers the case of the petitioners herein. The instant with petition stands disposed of by declaring that the petitioners herein would not be entitled to the pension in terms with the Assam Service Pension Rules 1969, as well as also shall not be entitled to subscribe to the fund in terms with the General Provident Fund Assam Services Rules 1937, but shall be governed by the new pension scheme applicable to the state government employees of corresponding rank. Further to that, this court further directs that the petitioner herein would be also entitled to the benefit of retirement gratuity and death gratuity on the same terms and conditions as are applicable to the employees covered by the rules of 1969 in view of the office memorandum dated 1/2/2021. With the above, the instant petition stands disposed.
Salary part.
Yes.
Lordship, my salaries may be released. Yes, sir.
Salary for what? You have not got your salary?
No. Since
From when?
95 to 2005.
Huh?
From
96 to 2005.
Yes, yes.
Nine.
Yes, Mr. K. Gogoi, you were
Lordship.
not there when the matter was
In
coming.
the court one matter was going on, Lordship.
Very well. Now tell me.
Lordship, in this matter, Lordship, I have got telephone instruction that all the petitioners have given the undertaking. So Lordship may give sometime, I will place the records, Lordship.
Undertaking for what?
Undertaking for recovery, Lordship. When there is a fixation of the UGC scale of pay, wrong fixation, Lordship. Here is the wrong
Okay.
fixation of pay, Lordship, as per UGC.
You have filed your affidavit.
Lordship, in all matters, Lordship, now this matter handed over to us, Lordship, but as per records, it was not filed. Not filed, Lordship.
As per record, there is only a body of the petition.
Lordship, I also got, so Lordship, then I will file the, by way of affidavit, I will place it, Lordship. Whole matter they have handed over to us recently, Lord.
I also have to take instruction whether they had.
As per UGC regulation 2010, Lordship, they have
Although
to,
this petition is of the year 2017,
Lordship.
there is a stay order passed
Stay here, and my lord, in the meantime,
until further order dated 13/6/2017, issued by the registrar so far as relates to the petitioner shall remain suspended.
Lordship, regarding recovery, that was recovery, Lordship.
Show me that 13/6/2017.
Question. 19/6/2007,
13/6, yeah.
13/6/105,
In pursuance to
Lordship.
the audit para of the Twenty in the matter of irregular fixation of pay of Twenty, What is the problem? This order, how does Rafiq Masi or anything will come in?
No, Lordship.
No, you see, have you seen 105?
Lordship.
All these people are retiring. This order is passed in 2017.
Lordship.
All these people are retiring after that, long
Lordship.
time after that.
Date of retirement is
Not
someone
1
is
year also
30
before.
32, someone is 40, Lordship.
Yes, then.
Lordship.
And in the meantime, my lord, one already retired, my lord.
Huh?
One petition number 6, my lord, he already retired.
Which one?
Professor Shashi Barua, petition number 6.
After filing of the writ petition, in
No,
2000
where is it? Shashi Borwa is retiring on 30th of September 2022.
Yes, my lord.
Lordship.
This order was passed in 2017.
Lordship.
Then
No, my lord, after that, my lord, there has been an attempt to recover this, in spite of this restraining order, my lord. Authorities have
Understood.
recover, my lord, from the pension dues, my
whatever
lord.
may be, this order was passed in 5 years before that order.
My lord.
Lordship.
Then how the Rafiq Masi or any case will come in?
Not come.
You have to
Not
return.
come in the way.
Why do you need to file a reply?
That's why, Lordship.
And I was also
No,
not
I
aware
have
that they have
asked-
signed this document, sir. That he has shown me some soft copy that I am also not aware that they have signed this.
No, but whatever may be, how will you apply Rafiq Masi if there is an excess payment which is being paid out there?
Right.
Rafiq Masi is a case where a person is going to retire within 1 year.
Even there is a grade 3 and grade 4 employee. He is a college research Lordship, grade 1 Lordship, university professor Lordship.
Not grade 3 or grade 4, it applies to everybody. But then also here, how will you apply that?
Not applicable Lordship.
Then-
Even exception covered in Rafiq Masi's case Lordship, 5 years there. within
Yes,
that
madam
Lordship.
wants to
I'm
something.
referring back of that. This is the Lordship today morning file our affidavit.
He saved Mr. Gogoi today.
Lordship, after 25th Lordship.
Huh?
After 25th Lordship, I will be out of station
Okay.
Lordship.
You want to bring on record,
Lordship,
bring on
I will
record.
produce the records. Only
Because
records.
otherwise this is
Lordship,
absolutely,
Lordship, only records.
that is why I wanted to see, because the order
Lordship.
and you see, in spite of that stay order, why I wanted to see that order was because on 29 2022,
Lordship.
there was another order passed
Lordship.
by this court,
Lordship.
Yes, ma'am.
passing a restraint.
Lordship.
Why was it necessary?
Only in the case of respondent 6, man, petitioner 6. Because my lord, he was retiring and there was an
There is
attempt to
a
recover
lordship,
from
some-
my
But
lord,
after getting a stay by you, where is the question of that?
Lordship.
This was done in 2017.
17 Lordship.
Then Rafiq Masing doesn't apply,
Lordship.
then you have to pay. Hello. Your affidavit is relevant.
They have just stated what is the exact right UGC Lordship pay scale. They have stated
ठीक
Lordship.
है, we'll have it on some other day.
Lordship.
Heard Mr. D. Gogoi, the learned counsel for the petitioner, Mr. K. Gogoi, appears for
Just when you have to. Lordship.
Tezpur University, and Miss,
UGC, respondent number 4.
give your name, I can't hear you, for respond number 4. It has been submitted by so-and-so, the learned counsel for respond number 4, that they have filed an affidavit today. The registry is directed to bring on record the said affidavit. Mr. K. Gogoi also submits that he would also like to file a short affidavit, bringing on record certain undertakings which the petitioner had submitted at the time of pay petition.
Lordship.
That the matter, such affidavit, the center, the Tezpur University shall file the affidavit. Let the honor before the next date, so fixed. List the matter again on 27.
Lordship, I will reach here on 25th. So Lordship, first week of May, Lordship, then will be
Okay. We'll have it on 3rd,
Lordship, Lordship.
3rd of May.
my lord, 3rd and 4th.
The
my lord.
affidavit should be filed by,
3rd and 4th, my lord, I'll be in Itanagar, my lord.
very well, I will also be there.
Yes, my lord. 4th, my lord.
We'll have it on 8th of May,
Lordship,
Uh,
Lordship.
and
my
the
lord,
affidavit be filed by
my
3rd
lord,
of
I'm
May.
very sorry. on 8, my lord, they pick to Kohima.
Okay, we dismiss the petition right now. Then you don't have any problem. Heard Mr. D. Gogoi, the learned counsel, appearing on behalf of the petitioner. Mr. K. Gogoi appears on behalf of the Tezpur University, which so and so appears on behalf of the respondent number 4. The petitioners herein have filed the incident with petition challenging the order dated 13/6/2017, whereby
My lord, not today, my lord, some other day. My lord.
no,
My
no,
lord,
I'm
coincidentally, my lord,
dismissing it now. You don't
No,
have
no,
a
my lord,
problem.
coincidentally, I don't know, my lord. How
No,
my
no,
lord
there
was
is no
not-
consequence. You
Then it
have
will-
somebody
let it be-
else. I'm not
my lord,
concerned.
let it be on third. Let
No,
it be on third. Let
it will
be on
be
third.
easier for me.
Let it be on third.
That
Let it be on third. Always, my lord. Always.
affidavit were filed on or before 28th of April.
My lord.
I'll do. Obliged. Such order, my lord, at page, what you will find at page 12.
Hmm.
My lord, later, my lord, I was denied salary. By the,
Since your appointment,
no, appointment was made, my lord, but at the, my bill for salary was refused by the treasury. So later, my lord, there were correspondence, my lord. It has come, my lord, further, it has come to our knowledge that, my lord, proper approval was not taken, and the approval from the finance department also was not taken. My lord, may I just to cut short, my lord, just I just want to show page of the affidavit by the respondents, my lord.
in which case,
In both the cases, in this case also, my lord, item 11 at page, my lord,
WPC number,
WFPC number 2189.
okay, affidavit filed with respond number 3,
Respond number, my lord, on behalf of respond number 1.
okay. On the number 1,
My lord, lordship will kindly see page 28.
page 28,
Yes, my lord.
yes.
Paragraph 6, my lord. May I read, my lord?
Yes.
It says, my lord, that with regard to the statement made in paragraph 6, the incident with petition, deponent begs to state that the appointment order of the settlement officer right this and this, that the appointment of the petitioner was made as per the letter number this and this, my lord. However, the DLR and 5, etc., is not the competent authority to accord approval for filing up the vacant post under the establishment of deputy commissioner. Government approval is mandatory in such cases, and it was not obtained by the settlement officer. Moreover, the DLR and 5, etc., has denied that any approval from appointment of the petitioner was accorded by the DLR. The IC DLR forwarded petition in original or a petitioner to the settlement officer. The DLR has informed the government by letter this and this. The word approve appears to have been inserted in DLR letter due to clerical mistake. And for all these things, my lord, we have to suffer, my lord. We are still on our job, my lord, till death, but no, not a single penny, my lord. And they say, my lord, approval was.
Mr. Borpujari,
And that particular order is at page, my lord. Page 41.
can these appointments happen without the SIU approval?
For appointment in a regular manner in a sanctioned vacant post, there has to be SIU approval, more particularly in view of the provisions of the AFRBM Act.
47/2005.
My lord, that provision.
Provisions.
Because without that approval, they don't have a budget. Because your money has to come from them.
Yes.
And they are not even to give a budget unless they approve it.
That is a fact.
Then
Now, my lord, only thing is
you want this court to legislate
no, my lord, not that.
or
my lord.
change the law?
But my lord, because of this, there were many.
Because 2005, when the act came, prior to that, it was the SLEC. After that, the SIU had come in. The SIU makes it clear that without the approval, the question of payment doesn't arise.
That for that it was refused.
Then
But my lord, approval was
why you are still working?
because my lord, I was
And why the government is entrusting them jobs? I don't understand.
and my lord, that too approval by the.
Why are you entrusting? You pay from your own pocket.
My lord, that this appointment was made by the my lord, the settlement officer, not by the my lord, the director or my lord.
Then why you are allowing them to still function?
They're still doing our.
Understood, schools are unmanageable. But how are people otherwise working out there in other grade 4 stuff in under the revenue department?
It cannot be allowed to my lord.
Then how is it happening?
Regarding my lord, that for
Yes, finance, why you are not taking say, some action, concrete action against the revenue? And school, there was a problem as regards provincialization. These people were not, we are still finding people even working in provincialized schools. That is another aspect. Why not the revenue department? How are they allowing those people who are not, whose appointments are not legal, not done as per the SIU approval, which is the mandate as per the act? Then who is going to pay to them? The deputy commissioner? Who is paying for the deputy commissioner? You are going to pay.
deputy commissioner is not met a party.
Huh? Deputy commissioner not made a party.
No.
It is in the deputy commissioner's establishment and you have not made them a party.
No, my
My lord, the settlement officer was made. Settlement officer. He was the-
Settlement officer.
He was the appointing officer.
Then how can they any amount be paid?
My lord, the order of the settlement officer says that my lord.
Where is your post appointment letter?
That is, I'm appointed on my lord at page number 12.
12. As per the director of land records, letter dated so and so in interest of public service, the following persons are hereby appointed as chairman, chainman in the pay band of so and so, plus grade 4 with allowance only on purely temporary subject to discharge at any point of time without showing any reasons thereof, and posted at the place showing against their names. How is it possible? Mr. Prabhujari, ROP is also given.
Yeah, this could not have been.
Was this pursuant to some selection proceeding?
No.
Then how is the settlement officer doing all these things? Have you taken any action when this has been brought to your notice?
No action has been taken.
It is just a my lord.
Isn't this a pure and simple case of illegal appointment? Then
And that too, my lord, he is appointed in the post of chainman. And other day, my lord was hearing the matters pertaining to Lakmandals and other day, my lord was hearing the matters pertaining to Lakmandal in Patwaris.
Yeah.
Those, my lord, a definite selection procedure is my lord undertaken. Here is a case where the selection procedure is per se absent.
nothing. Was there any selection?
No.
Then
We were retrenched, my lord.
they liked you. The settlement officer must have liked you and appointed you.
My lord, because these people
And that too in ROP.
retrenched, my lord.
I would have understood these people being given out there for casual for 1 or 2 months for that purpose out there.
My lord,
And how can, when they are posts out there, how can they be a temporary appointment? If they are posts,
These are vacant posts. Thanks, sir.
my lord, at page 12 of the writ petition,
yes,
this is the order of appointment.
yes, that is what I've looked
Yes.
into. See, they have been given the ROP payment one.
ROP, I don't know how it is.
Then You file a civil suit against that person concerned, better off asking. How is it possible?
That is probably
Because the treasury officer cannot release salary.
Obviously, the treasury officer can't release, nothing can be processed unless something is done. And I don't understand how the revenue department is still allowing them to function. And these appointment order happened in 2013, almost a year back, 10 years back.
Yes.
And they are functioning for 10 years. And this is a repetition filed in 2019. I would have understood in 2019, something must have come to their minds to that effect that we should not further engage these people.
Yes, ma'am.
I can also say
And what is the other case?
same, my lord.
Same.
By the same order, 2 persons were appointed.
In fact, at page number
In
12,
different places, my lord.
page number 12 of this writ petition, Lordship will find mention of petitioners in both the cases.
Yes, yes, I've seen it.
It's a
Page
common
number,
order, my lord.
yes, my lord, Dulal Tior and Tapas
Tapas.
Kumar Chaudhary. Because post the earmark, my lord, then selection process takes place. Everything is, my lord, it is preconceived. Tension থেকে regular
This appointment of chairman is done under the ministerial rules? Or under what provision?
Chairman, my lord, it is done under the
It's service
provisions
code
of
also.
the land revenue regulation, my lord, some executive instructions are there. And also, my lord, a particular set of rules are also there.
They are not under the ministerial rules. None of it.
I'll have to check it, my lord.
These are fourth grade.
Okay.
Fourth grades are not involved in these two ministerial rules. How do you appoint these fourth grades?
There is a selection process, my lord.
Where?
That, my lord, perhaps has been called out in the executive instruction while checking it.
Of?
The executive instructions, my lord, under the land revenue regulation.
Oh, land revenue regulation. ठीक. I don't think the executive instructions have anything
Even
to do.
executive instructions were otherwise contained, my lord, with regard to provisions with regard to appointment of Gamulas. I'm just checking it out, my lord.
Yes, Mr. Hendrik, how have you appointed these people? How do you appoint chairman? It is your department.
Lordship,
And how do you appoint chairman? You must, as you are having vacant posts,
my lord, vacant, in a vacant post, my lord, it has been
how
appointed.
a person is appointed?
Rule. Lordship, may I wait just some time to bring the instruction, my lord, how, my lord, that chairman has been appointed. Will better, lord.
Okay. Or Mr. J. Hazarika?
TH Hazard.
TH
Lordship, may kindly put that query in the order, it will give us a handle, my lord, to see the instruction.
Which one? I put 4 queries.
Appointment of chairman. How it is made.
The provisions, my lord, and the rules. on
That
the-
obviously that I'm going to
Yes,
put.
yes, yes.
I'm also thinking of putting under what means.
Yes, and this appointment also,
Now, how are they being allowed to function?
because it appears from this page 12 appointment order, it was issued in pursuance of.
And how are you assigning? How is the revenue department still assigning them? Their appointment has not been regularized, and after these affidavits, if they are doing it, then they should pay from their own pocket, those officials. Mr. T.H. Hazarika, the learned counsel appearing on behalf of the petitioner. Mr. R. Pujari appears for the finance department. Mr. J. Hendrik appears on behalf of the revenue department. Upon hearing the matter, this court had put a specific question upon Mr. J. Hendrik as to under what provision a chairman is appointed, and does such appointment and as to whether such appointment is preceded by any selection process. This court further have also raised another query as to whether without taking the SIU approval, which is required after 4/7/2005 in pursuance to the AFRBM Act of 2005. How the petitioner, by an order dated 22/10/2013, the settlement officer, Dhubri and Kokrajhar, had appointed the petitioner as chairman in payment 1, thereby entitling the petitioner to pay in terms with the ROP rules of 2010. The said aspect of the matter be brought by way of an affidavit, which shall be filed by 3rd of May 2023. List the matter again on 8th of May 2023.
Deeply obliged.
Mr. Hendrik, you File your affidavit, take note of this order. You get that order nowadays in online.
Lord,
Now send it to the officials.
13,
Please, my lord. This
Yes.
matter relates to pension to unmarried daughters.
May I please your lordship, already pension payment order has already been issued in favor of the petitioner. my lord.
Hey, you got it.
Yes, yes, my lord, there is no submission, my lord. In this order, my
Copy
lord,
to
the
the
date
petitioner,
from which the monthly family pension will be paid is not mentioned. And my lord, after receiving this order, petitioner reacts to appear before the treasury officer Ramakrishna Nagar, my lord. Petitioner appeared, but treasury officer told her that, my lord, pension payment order was not received, my lord, by the treasury officer Ramakrishna Nagar. So
Already copy has
in
been
almost
sent.
2 months, my lord. Even yesterday, petitioner
Where is
went
the
to-
finance?
my lord. Yes, my lord, notification.
Finance is made a party here.
Yes, my lord. Respond number 2, my lord.
Treasury officer Karimganj.
That is my lord.
Treasury officer
That is
Ramakrishna
sent
Nagar.
to treasury officer
Ramakrishna Nagar.
And Ramakrishna Nagar treasury officer was not made party, my lord.
It's okay, no problem.
And my lord, as per
The finance will take action in that regard. Don't worry.
and as per
Now the
notification,
PPO has been made. Now this PPO having been made, now this PPO informs you that you will be entitled to family pension. So accordingly, the treasury officer will direct the treasury officer Ramakrishna Nagar to do the needful pursuant to the affidavit being filed, certified copy on the basis of the certified copy of this order.
And one more thing, my lord.
From
Page
this
28, my
instruction
lord,
letter, my
notification,
lord,
my
it already appears that, my lord, on 17th of February,
Hmm.
this direct, my lord, mandate has been issued by the.
To the treasury officer
Yes,
Ramakrishna Nagar.
Yes, yes,
So you do-
we will act upon.
heard, mister.
Excuse me,
What else do you want?
my lord, that is the date from which, my lord, pension will be paid is not mentioned in this order, my lord. As per notification, my lord, note key, my lord, the pension will be paid on the date of notification, your application, my lord. Page 28, my lord, read petition.
Then, my lord, it will require, my lord, a decision from the accountant general, because the treasury officer is only the executing authority.
You are entitled to pension from when?
From the date of application, my lord. Application is filed on.
From 17/5.
27/11/2018, my lord. And on that day itself, my lord, application was forwarded by the commandant, my lord. It is on record, my lord, annexer. Annexer K, my lord, page 46, my lord, in my petition.
Annexer?
K, page 46, my lord. Commandant forwarded the application with the document.
Okay.
Now,
Heard, mister.
SK Sinha.
S.K. Sinha, the learning counsel appearing on behalf of the petitioner. Mr.
R. Mujumdar for respondent number 6.
You are R. Mujumdar. R. Mujumdar for respondent number, for the accountant,
General.
for the principal accountant general AE Assam. Mr. R. Borpujari appears on behalf of
My lord, 2 and
the
7. 2 and 7, my lord.
respondent number 2 and 7, and Ms. A. Talukdar appears on behalf of the director of pension,
No, no,
for the director of pension. The case of the petitioners herein is that they are entitled to the family pension.
excuse me, my lord. One, my lord. Petitioner number 2 expired, my lord. I brought the certificate, death certificate, my lord, by way of additional affidavit.
The case of the petitioner herein is that they are entitled to the family pension upon the death of their father,
Yes.
as they are unmarried dependent daughters of late Brajamoni Singh. It has been brought to the attention of this court by the learned counsel for the petitioner that in the meantime, during the pendency of the writ petition, the petition number 2 had expired. And it is only the petitioner number 1 who would now be entitled to the family pension. The learned counsel appearing on behalf of the Principal Accountant General AE had submitted that a pension payment, family pension payment order number 932-422 297823 have been issued in favor of the petitioner number 1. Thereby entitling the petitioner to an amount of rupees, petitioner number 1 to an amount of rupees 8760 per month. On the basis thereof, a communication has also been issued on 17/2/2023 to the Treasury Officer Ramakrishna Nagar for payment of the family pension to the petitioner number 1. The learned counsel for the petitioner has submitted that the said communication dated 17/2/2023 does not mention from which period the petitioner number 1 would be entitled to, taking into account that the petitioner's entitlement dates back to 27/11/2018. The learned counsel appearing on behalf of the Principal Accountant General AE shall apprise this court on the next date as to from when the petitioner number 1 would be entitled to the family pension. In the meantime, the the Treasury Officer Ramakrishna Nagar is directed to disburse the the family pension to the petitioner number 1 on the basis of the order dated 17/2/2023. The petitioner is directed to serve a copy of the instant order to the Treasury Officer Ramakrishna Nagar for due compliance. List the matter again on when, Mr. This is only a clarification required.
Treasury. It is with Treasury.
Huh?
Treasury.
You.
AG. I am for the AG, accounting general.
That is what you have made this. You have not mentioned
In
from
the
when he
pension-
will be
Your
entitled
Lordship,
to
in
it.
the pension payment order, the date are not mentioned. She will automatically get from the entitled date, your Lordship.
You give that clarification. Because here it is not mentioned, here only 8760 per
Yes,
month will
yes.
be entitled to, has been given. But what about the earlier period? Earlier period, she says about for 5 years down the line.
Yes, she will get, your Lordship.
If she gets, it's well and fine. You just give a clarification to the effect. We'll have it on 26th then. Get your clarification. The copy of this is the matter again on 26th of April 2023. the copy of the pension, the communication dated 7/2/2023 is kept on record and marked with the letter X.
All right.
14. Yes,
Meter.
I can't hear you. Mr.
Meter
Pulja,
has become
can you hear?
infructuous.
Huh?
Infructuous.
Oh, instruction.
Yes, sir.
Your name?
Here, Purva.
Heard Miss K. Borua, the learned counsel, appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the Elementary Education Department. It has been submitted by the learned counsel for the petitioner that the instant writ petition has become infructuous. Taking into account the same, the instant petition stands closed as being infructuous.
15.
Oh, yes, this matter.
Have please, Your Lordship.
Yes, this matter again comes back to me. Tell me.
Yes, sir. Lordship.
Yes,
Chair
I
will
think
open.
the finance,
In the meantime, the additional affidavits so filed by the petitioners be brought on record. Yes,
Yes,
what is your additional affidavit? Types of copies of appointment letters of the petitioners.
On the last occasion, Your Lordship, I was asked to clarify few things to the additional affidavit, Your Lordship. Whether they are
93,
graduate.
93, 93.
Shall I, Your Lordship?
What do you want here? What is your prayer?
Lordship, yes. My grievance is that, Your Lordship, they have reduced my pay scale, Your Lordship.
Okay,
Yes.
they have reduced it from 5,000 great pay
Yes, Your Lordship.
from 8,700 to 5,400,
No, from 8,700 to 6,800.
6,800.
Yes, Your Lordship.
Very well.
I was asked to produce
8,400.
it.
Where is it?
The Lordship, the degree certificates are on annexure number 8A,
Salary certificate,
salary certificates.
great pay of 8,700.
Yes, Your Lordship.
Then it has been made to 5,000.
Not 5,000, Your Lordship. First it was made 6,200, then later on it was made 6,800.
6,800.
Yes, Your Lordship. Lordship, shall I-
Now tell me,
Yes, Your Lordship. So what happened in this case?
no, whatever they have done is done.
Yes.
I'm not on that.
Okay, Lordship.
Your entitlement of 6,800 or 8,700
Yes, Your Lordship.
is on what basis?
Yes, Your Lordship. I like to take you to page number 10, Your Lordship.
Of
Page number 10, Your Lordship. Yes, page number 61 of additional affidavit, Your Lordship.
61.
Annexure number 10.
Yes.
Pardon me, Your Lordship.
Very well.
The
Tell
page
me.
number 61, Your Lordship. Annexure number 10, Your Lordship. Additional affidavit, Your Lordship.
Hmm.
Lordship, kindly come to
You are graduate?
graduate teacher, Your Lordship. I have annexed my degree certificates, Your Lordship, in the additional affidavit, Your Lordship. So here, kindly come to this junior basic pre-primary schools, Your Lordship. Second one, Your Lordship. Graduate teacher, pay band, Your Lordship. Kindly say 8,700, which I am also entitled to, Your Lordship. We are also entitled to, Your Lordship. There are many of us, Your Lordship. Now, Your Lordship, shall I, Your Lordship?
You are trained graduate teacher?
Yes. Lordship, what happened, Lordship?
They had a problem
Yes,
when
no,
I
no,
was there.
no, Your Lordship. Annexure number 1, 2, and 3 have specifically stated that because there are many of us, we have been appointed much before 3rd September 2001, Your Lordship. Kindly come to main petition, Your Lordship. Annexure number 1, 2, and 3, Your Lordship.
Hmm.
As we have been appointed much before 3rd September 2000, and we do not require to undergo the particular training. And it was only for the people, only for the teachers who were appointed after 3rd September 2001, Your Lordship. It is clearly given in annexure number
Annexure?
1, 2, and 3, Your Lordship. One by one, I go
1,
through.
2, and 3 page.
Yes. Give me a moment, Your Lordship. Annexure number 1 is page number 15, Your Lordship.
Page number 15.
I should directly take you to last para, Your Lordship.
15. Yes.
In this regard, you are requested to submit a detailed status of the teachers appointed on or after 3rd September 2001 academically unqualified as format enclosed herewith. Now, your lordship, I'll take to be a little fast. I'll take you to page number 18, your lordship, annex number 2, your lordship.
No, madam, first of all, are you trained?
I have been considered as trained because of these 3 annexures.
No, forget about the annexure.
Yes, I'm trained, your lordship.
You are trained.
Yes,
So you are a trained teacher.
yes, your
Then
lordship.
why you are going into this or that? You are not on that. You are a trained teacher.
Yes, your lordship.
Very. You were appointed under what provision?
That is the lordship in additional affidavit, your lordship. My appointment letters are in appointment letter 6A, lordship,
Okay.
page number.
You were appointed against.
We were appointed as assistant teachers. There were no such category at that time, your lordship.
No, there is.
At that time, your lordship, we were appointed as assistant teachers. Page number 34, your lordship. Lordship, I'd like to take you to page number 31, your lordship.
So you were appointed in 93, 94.
Yes, your lordship.
Very
Long
well.
back. Every one of us. Your lordship.
Where 93, 94 you were appointed.
Yes, your lordship.
Now, thereafter, so this appointment was done under the 77 rules. Mr. Prama.
Perhaps, because
Hmm.
it should be under 77 rules. Okay.
Huh?
It should be in the under 77.
77. Now, once they are 77 rules, now this graduate teacher, who is a graduate teacher? This graduate teacher business have come only in as per the 2017 Act. Or was it before that? Okay. Yes, Mr. Khatonia.
Yes, madam.
This graduate teacher business is where?
It has been introduced in the 2003 rules, madam, in case of ME school,
In case of ME school,
high school, my lord,
2003 secondary.
secondary education. Their definition is there, my lord.
Okay.
360. Two N, my lord, fixed. Rule 2N.
Means the category of assistant teacher in higher secondary, higher and multi-purpose school for whose appointment, the minimum qualification is graduate degree in arts, science or commerce, including higher secondary, and so purpose school. So he has to be a graduate.
Yes, my lord.
And the petitioners are graduate.
Yes, your lordship. I have annexed the degree certificates, your lordship. Annexure from annexure 8, your lordship. Page
Well,
number 58.
Now the question is comes under trained and untrained. Where is the concept of trained and untrained?
Yes, your lordship. Let us-
Where? Under what provision? Training is done. This training I could see out there in the 2000 secondary 2003. Another one, secondary education, 2018.
Lordship, can I, lord? Lordship, kindly come to annexure number 2, your lord. Main petition, your lordship. Page number 19, your lordship.
Now, if we see the 2018 rules, Mr. Khatoni, Mr. Sharma,
The-
2018 rules, it says about the training. A member of a service may be required to undergo such training as the government may prescribe. Because these orders which she has enclosed are all of 2018.
Lordship.
I think prior to that also, let us see, here also there will be a training business. You come under secondary or elementary?
Elementary.
Elementary.
You're elementary.
Elementary.
Elementary, then why not the 81 rules?
Just training. 13. 230.
Rule 213, my lord. This provision. Rule 213, definition. 81 rules.
No, it is there, section 4. Rule 4. Because these people were appointed in 1993.
Lordship.
So they will be under the 73, 77.
77.
And if you see 77 rule 3(9), Roman 9. Last page.
Lord. Nine. Appointed candidate may be required to undergo such in-service training as the government may decide.
So this is 3(9).
Lordship.
But in the other one, if you see section 3, rule 3 of the 81 rules,
81 rules.
it categorically mandates that they have to go for a training. Rule 3, you will find that.
Lord.
An appointed candidate has to undergo a training.
The teacher.
Isn't it?
Lordship,
3, rule 3,
4, 5,
3, 5.
3, 5, Lordship,
Ah, this is 3 Roman 5.
3 Roman.
So what is this concept of train untrained? She's saying that she is not required to undergo a training. Why? She's saying on the basis of what? What is your basis?
Lordship, the circular that came from them, your lordship, annexure number 2, your lordship,
What does annexure number 2 say?
page number 19, your lordship.
Yes. What does it
However,
say?
all these teachers appointed or regularized before 3rd September 2001 are treated as trained teachers as per NCTE norms. And lordship, we were never hesitant to undergo training. We were not detailed for the training.
But
If we
this
are
is
asked
an
to, we will go.
instruction being issued by the district mission coordinator to the block mission coordinator of Home Sarva Shiksha Abhigyan Mission. So you were appointed here under the Assam Sarva Shiksha.
No, I was not appointed by this mission, but this while we were in the service, this was given to us to undergo the training to the people who were appointed after.
How will this thing apply for them, for you?
Because of this, they have some of
Who
the
is Sarva
teachers,
Shiksha?
lordship.
How do you apply this one to the government schools? The people appointed before 3/9/2001?
All the teachers appointed and regularized before 3rd September 2001 are treated as trained teachers as per NCT now.
This is under what provision this is being done? And can a district mission coordinator say something to that effect? Yes, Mr. Borpujari. You appear for everybody. What is this Sarva Shiksha thing? Can a person say that, that it will apply to all schools also?
Perhaps this needs to be clarified, my lord, by the council for appearing for SSA.
No, whatever may be, can SSA say that for other people who is not involved with SSA, that those people who were appointed prior to 3rd of September 2001 will be considered to be trained teacher if the rules does not prescribe so? And what is this concept of trained and untrained? Because here, if you see, kindly come to the affidavit, additional affidavit which she has filed at page 61, running page. There the concept is graduate teacher. The trained, untrained business is not there.
Yes, this is the, my lord.
As per the ROP.
Yes,
Now, if they are graduate teachers,
Yes.
would they not be entitled to the grade pay of 8,700? The payment is same.
Yes,
It is only the grade pay.
great pay.
Earlier, the grade pay was 6. She has been given 6,200. Because the ROP rules does not distinguish between training and no training.
Yes.
We have to go as per the ROP.
Well, earlier it was 2,700, it was increased, my lord, on the recommendation of the 7 pay commission to the quantum of rupees 6,800. That, my lord, will find, my lord, from the WT message at page 24 of the writ petition. Page 24.
23. In continuation of government district to 28, 23, na?
Page
24.
24, page 24 of the writ petition. my lord.
Assam Pay Commission has recommended pay grade pay of 6,000 to all officials.
6,800 to all the officers in general who were drawing grade pay of rupees 2,700 as per recommendation of 6 pay commission. Government has decided to allow grade pay of rupees 6,800 to all the elementary teachers who were drawing grade pay of rupees 2,700 as per recommendation of the 6 pay commission. As far as the demand of the teachers associations for higher grade pay is concerned, it is intimated that the same is being examined by the anomaly committee and the report of the anomaly committee is awaited. And when the report of anomaly committee is accepted, necessary clarification if required will be issued. Now from 2,700, it was
No,
increased
kindly
to-
come to page 62.
Yes.
Because this was given in 2017, 3rd of
17.
November 2017.
Yes,
Now kindly come to 4th of August 2018. This
yes,
is the order of the governor by which the ROP was changed.
yes,
The following amendments shall be made to the schedule of Assam ROP published in the extraordinary gazette on so and so, 7th of March, so and under the head of the year. So now what they have done, brought in this grade pay of headmaster, ME school, senior basic school. This is the payment 2, grade pay 3,300. Now 2,700 is being given,
yes,
8,700
8,700,
to
yes,
train graduate teachers.
yes,
And then you are having untrained graduate teacher, including trained undergraduate and teacher of untrained undergraduate.
yes.
They are being given 6,800.
6,800, because Lordship will prima facie see in between these two classes of employees. The first one is the trained graduate teacher. That payment is, my lord, same. And my lord, the grade pay is different. Grade pay is, my lord, for trained graduate teacher, it is 2,700. That has been increased to, my lord, 8,700. Then, my lord, the third column, Lordship will find,
Untrained.
yes, third row, Lordship will find untrained graduate teacher, including trained undergraduate teacher and untrained undergraduate.
Hmm.
So, my lord, the benchmark here is graduate. One has to be first of all graduate, then, my lord, the question of training or untraining.
If a person who is graduate
My lord.
but trained,
Yes.
8,700,
8,000.
untrained is
Yes,
6,800.
because definitely they are having less qualification.
Wait,
They are having less
no,
qualification.
no,
That-
there's no quarrel with that.
Yes.
But where is the concept of training?
But that, my lord, my colleague may be able to.
No,
Clarify.
she comes up with a thing that there is some letter by Sarva Shiksha. How does the Sarva Shiksha will have anything to do with the normal school?
So therefore, my lord, she is claiming, my lord, on the basis of this row number 2, trained graduate teacher, 8,700.
Understood,
Yes.
Mr. Corpusary.
Yes.
That aspect I have understood. I have understood that she is claiming that she is not required to be trained because she has been appointed prior to 3rd of September 2001.
Yes.
Isn't that your case?
Yes. So that
But
is,
the question is that has been done on the basis of Sarva Shiksha. How does the
yes,
Sarva Shiksha control this?
yes.
Isn't that an independent
Yes,
body?
yes, independent, and that is, my lord, an intra-office communication. It is not an office memorandum or notification. It is not. a-
Understood, but
Yes.
whatever may be,
Yes.
can Sarva Shiksha dictate?
That perhaps, my lord, the SSA council will be able to clarify before his honorable court, whether that will have a bearing, because she is claiming.
Because here she's concerned out here, because she comes from the normal cadre. She is not from SSA.
Therefore, she is seeking the benefit under that particular letter. Because
So
that-
under what, therefore, this court wants to know
Yes.
from you, Mr. Sharma, what is this basis? On what basis you are saying about the training? Training under what?
established court that she is a trained graduate teacher. For that reason, my lord, she is seeking the leverage of this particular communication, which is giving a leeway to her. So therefore, my lord, whether this applies, this can be applied, this can be read into the provisions of, my lord, ROP rules that can be only be clarified by, my lord, Sarva Shiksha Office and Council. Because ROP is there, my lord, the provisions of the rules are there, acts are there, lordship has prerogative. In between, this has come.
No. The education department has to say as to whether that communication have any impact on the normal thing. Why should we bring another Sarva Shiksha out there? Can Sarva Shiksha Council come out here or Sarva Shiksha say that all my rules and will also be applicable to the education department? No. Education department is the general cadre of the state.
It is there.
Tomorrow the National Health Mission will say that all our orders has to be followed by the Health and Family Welfare Department. Would the Health and Family Welfare Department agree to that? Although the counsel of both remains the same.
No, no, why I am making this submission, this page 18 of the writ petition, the
Yeah.
letter, on the strength of which she is laying a claim. But this is a communication.
Whatever may be, it is for the Education Department to say out here as to whether they are bound by this, whether they require, what is the training they are saying about?
Then they will-
Is it a training as per the rules? If it is a training under the rules, it will be different. Sarva Shiksha would be different. Sarva Shiksha will be regulated as per their own. It is if I'm not wrong, it is some society or something to that effect. So they are regulated by them. They may say that those people are as per. Now, that is why the importance is as regard the NCTE. Now, NCTE comes where? It has to be somewhere. Where is the NCTE rules? Because there, the reference out there is made to the NCTE rules,
NCT norm.
the norms.
Yes.
And if it is an NCTE norms which says that a person concerned, because NCTE is also being followed by the Education Department. Now, if it is the Education Department, NCTE norm says that a person who has been appointed or regularized prior to 3rd of September 2001 is not required. Matter is there. Isn't it, madam? Heard, miss, your name?
The SSA is a party respondent here, mission director, that's R3.
And they don't appear.
R3 is already there. But NCT, of course, is not a party respondent.
Huh?
NCT is, of course, not a party.
No, no,
respondent.
NCT is not required. NCT, tomorrow, are you going to make the UGC a party for all those matters? No. Heard, miss, your name? P. Das, the learned counsel for the petitioner. Mr. P.N. Sharma appears on behalf of how much court fee you have paid? Oh, you pay the deficit court fee.
I'll pay whatever is required.
Yes, you pay. Heard Mr. Miss so-and-so, the learned counsel for the petitioner, Mr. P.N. Sharma appears on behalf of the respondent number 1, 2, 1 and 2. None appears on behalf of the mission director, SSA. To stop. Mr. Arbor Pujari appears on behalf of the respondent number 4. To stop. Upon hearing the matter at length, a relevant aspect has come into light as to whether the petitioners, having been appointed and regularized prior to September, what September?
3rd September,
3rd September 2021,
no, 2001.
2001, would be deemed to be trained teachers within the ambit of the notification dated 4/8/2018 issued by the 4/8/2018, whereby the Assam Service bracket ROP rules 2017 was amended. The learned counsel appearing on behalf of the learned departments, the departments that is the respondent departments, that is the respondent number 1 and 2, as well as the respondent number 4, shall file an affidavit as to what is meant as regards the query so raised in the instant, so raised by this court. Let the matter be again listed on 3rd of May 2023. The affidavits be filed by 28th of April. Mr. Borbujari, you file an affidavit. Bring on record. What do you mean by trained? Because it is done under the aegis of the the finance, this ROP thing. Now, what do you mean by this trained teacher? Because that is the basic idea. It is done under this amendment has been done under the aegis of the finance. And you say as regards whether a person who have been appointed prior to 3rd of September 2001 would be a trained teacher as per your department. Check the NCA.
Kindly grant us some more time, my lord.
Okay, we'll have it on 10th. File the affidavit by 3rd.
Item number 76 of the supplementary list, which is fit for instruction relating to post-retirement benefit. I could not make a mention. Can it be updated?
It is not there?
Not there. I was late, my lord. I was.
Okay. Put it out.
What is for judgment today?
No, it is order. It is treated.
We were a little confused.
They're not used to it. I framed the terms of reference to the commission. Whether on the facts of the present case, the permanent disability of the child of the petitioner could have been prevented by the respondent health department. Whether there was medical negligence on the part of the respondent health department which led to the permanent disability of the child. What medical remedial steps are required to be taken for the child of the petitioner to live a life with dignity. So this is the plan. You can very well, you are to submit all your documents. The parties are directed to appear before the commission and place their respective materials, including medical reports, etc., on such date as may be fixed by the commission, so that the commission is in a position to render the opinion sought for. The commission shall submit the report within 2 months from the date a copy of the order is served upon the members of the commission. The registry is directed to serve a copy of this order to the members of the commission so constituted forthwith. The commission shall have the power to call for all such records as deemed necessary, as well as also call for such witness as deemed fit to arrive at an opinion in terms with the reference so made. This court fixes an honorarium of rupees 25,000 to be paid to each of the members of the commission, which shall be paid by the Department of Health and Family Welfare, Government of Assam. Further to that, the Department of Health and Family Welfare, Government of Assam shall provide an appropriate place for holding the commission and would also provide secretarial assistance. In the circumstance, if secretarial assistance is not provided, the Department of Health and Family Welfare, Government of Assam shall reimburse such costs incurred by the members of the commission on account of secretarial assistance. List the matter again on 15/6/2023 for report. Madam, you kindly have a look at this order. If anything else has been left out, just have a look.
Item number 6, Parker. Sorry, not Parker. Item number 6, for admission.
Lordship, before my learned friend starts, we were directed to bring the record in this case. And the record already we have received, Lordship. May I pray for a little bit accommodation, Lordship, after the vacation, immediately after the vacation.
What is the matter about?
The departmental inquiry was conducted against the person after his retirement. His claim is that
sanction of the governor, which is required under Rule 21, was not obtained. That is why the record was called for, Lordship. But Lordship, I have find some difficulty in going through the records,
Well,
Lordship.
let me have a look. You have it?
Lordship,
I'll find. Don't worry.
Lordship, otherwise, Lordship also, I have
Otherwise
also
what?
not gone through Lordship properly. That is why I'm praying,
You
Lordship.
can
If it is
improve.
not
Mr.
inconvenient.
Sharma, you can improve the records.
No, Lordship. But there I have seen,
Yeah.
most probably some other records will be required as because the record which each have received, there the number, the page number 25, and in some page number 25N. That 25N I am unable to find it out. Most probably it is in some other. That is why this most probably required, Lordship. That is why, Lord. The person of the personnel department will be required, Lordship, so that we can. If that is the case,
No,
Lordship, my learned friend.
now tell me, Mr. Datta, where is the question of requiring the previous sanction of the governor? Is it required as per Rule 21?
Yes. Since it was after the retirement, my lord, the proceeding was initiated after retirement. The
Is it
show
so?
cause was issued after retirement. 21B, my lord.
Yes, 21.
21, my lord, 21.
Such departmental proceedings, if not instituted while the officer was in service, whether before or his retirement or during his employment, shall not be instituted save with the sanction of the governor of Assam. So we have to look into the small
Yes,
thing,
Lordship, but
whether you have taken the sanction.
yes.
Where is it?
No, Lordship, the record, Lordship, I have seen that certain this page, Lordship. Yes, Lordship, I have examined. This Lordship, I am just pointing out
Only
one.
thing which is necessary is whether there is a sanction of the governor. Nothing else.
I am trying to find it, or I am just, Lordship, pointing it out. Since the charge sheet could not be served within 31/1/2002, that is the date of his retirement, before retirement of C so and so, it will have to be served now with modification of the first paragraph. With the page number 28N, I am unable to find it out. Page number
No,
20.
no, that is there. But
The-
sanction of the governor,
No, I could not.
it will be there.
That is why,
I
Lordship.
have kept the second aspect open. I have kept the second aspect as regards constitutional thought open. Two aspects.
Deeply obliged.
That is why I am praying, Lordship. Some a little bit accommodation.
Okay, this is a matter of 2016. It doesn't
Lordship,
look
Lordship, I
nice.
appreciate, Lordship. Even
Okay.
I have gone through the.
Okay, I heard Mr. M. Datta, the learned counsel, appearing on behalf of the petitioner. Mr. H. Sharma appears on behalf of the, which department?
Lordship's personnel department.
Appears on behalf of the personnel department. Mr. Sharma submits that the records have been received. However, he requires some accommodation to go through the records.
Lordship.
List the matter again on 20th of April 20.
20, Lordship.
Deeply obliged.
Much obliged.
28th of 20.
Hello, 10.
Classification, my lord, it took time for instruction.
Lordship, everything has been paid, your lordship,
Oh.
area salary and
There you got
they're
everything.
receiving the current salary also.
Arrears salary, I have not received arrears salary.
Lordship, my instruction is that they have received.
You have got the instruction?
Lordship, in papers, I don't have, your lordship, but
You have got-
ISS inspector of schools,
Yeah.
he just now informed me
How,
that the area has been paid, your lordship.
how has he informed you?
Lordship, through
Arrears salary, my lord, in case of, in my petition, my lord, that he the suspension at the instance of
Okay,
this
okay.
honorable court.
We'll do one thing. Heard Mr. A.K. Datta, the learned counsel, appearing on behalf of the petitioner. Ms. D. Musari appears on behalf of the Secondary Education Department. It has been submitted by Ms. D. Musari that the area salary as well as the
current salary.
current salary of the petitioner have been duly paid. However, she submits that she doesn't have the documents on paper to substantiate the same. List the matter on 19th of April 2023
19.
on
Later, my lord,
on 21st of April 2023, on which date Ms. B. Mutari, the learned counsel, shall apprise this court with shall produce the documents to show that the area salary as well as the current salary is being paid to the petitioner.
Obliged.
17.
Yes, Mr. H. Das.
Instructions. Lordship, in this case, we have resubmitted the pension papers to the AG, Lordship. My friend, now.
That happened on 14/12 also.
It is resubmission, Lordship. They have some in queries were there from the raised by the AG, Lordship. Now it is resubmitted, Lordship. This is the instruction.
So you have resubmitted.
Lordship.
So on 2/3 you have submitted.
Lordship.
So we'll have a call sometime on 17th of May. Okay.
In the meantime, if it is in order, my lord, we will settle.
We will price this court.
Lord.
Heard Mr. H. Das, the learned counsel, appearing on behalf of the petition. Mr. N. Upadhyay appears on behalf of the irrigation department, and Mr. A. Hassan appears on behalf of the accountant general AE. Learned counsel for the irrigation department has submitted that on 2/3/2023, the Undersecretary to the Government of Assam Irrigation Department had resubmitted the pension proposal to the Accountant General Assam by the communication dated 2/3/2023. The said communication has been produced before this court during the course of hearing. The said communication is kept on record and marked with the letter X or Y, with the letter Y. The learned counsel appearing on behalf of the Accountant General AE shall apprise the court as regards the status of the pension proposal of the petitioner on the next date. So fixed. List the matter again on 17th of May 2023. When did you retire?
1/2/2015.
It is relevant to take note of that the petitioner had retired as on 1/2/2015. Until
31/5.
What?
31/5/2015.
You don't know your date of retirement?
Pension I claim for
I'm not asking you, when did you retire?
31, my lord, 1/2015.
31/1/2015. It is relevant to take note of that the petitioner had retired on 31/1/2015, and almost 8 years have passed by. But the petitioner have not received the pension as well as the pensionary benefits. Have you got anything?
No.
Provisional?
Terminal gratuity received, my lord.
Huh?
Terminal.
What is this terminal gratuity business? Terminal gratuity is given to people who is not entitled to pension. Death come retirement gratuity is different.
6 was
You have
deducted.
not read your file
Before-
and are appearing.
6 years deduction was.
Mr. Das, you know.
No, 6
You are-
years, 6 years deduction, matlab prior to 6 years deduction, those are the employee able to receive only the terminal gratuity. Subsequently, it was adjusted, regularized after that Sanjita's judgment, my lord.
Lordship, he himself submitted 2
My lord,
certificates
there-
of date
there
of
is a
birth.
discrepancy in the date of birth, my lord. He, my lord, along with the pension papers, my lord, submitted 2 certificates where 2 different dates of birth, my lord, recorded. That's why we have to return the pension proposal.
Yes, what is your date of birth? You don't know. It is similar to your date of retirement.
Corrected, my lord. already.
Which one?
My date of birth already corrected, my lord. I have even submitted there, my. Already.
So
that-
your date of retirement is sure.
Yes, my lord. Sure.
On 31/1/2015,
Yes, my lord.
and almost
these are
8
the
years have passed by.
Two certificates, my lord.
Under such circumstances, the respondent authorities are directed to ensure and expedite the process of pension.
Obliged.
31.
Made Vijala.
Yes, what is the state of affairs as regards the
Lordship, it was
inquiry?
communicated.
Lordship, on the earlier occasion, Lordship wanted to know whether that said appointment of the inquiry and presiding officer was communicated to the petitioner or not, Lordship. It was
Fully
communicated to him.
are appointed as inquiry and presenting officer in connection with departmental proceedings. You are hereby informed that you have been seen, you may see the documents and materials of
It's serial number 3.
request you to appear before the inquiry officer.
It was 13/1/2023.
Who is this receive? Principal? Who is principal?
Lordship, it is Principal Prajyotis College, but serial number 3 is the petitioner, Lordship.
Huh?
Copy to Lordship, serial number 3, Manav Deka is the petitioner, Lordship.
Where is it?
Serial number 3, Lordship. In that first page, Lordship, copy to.
No, that is okay. I'm not on that. But the second page,
Yes, Lordship, it was
this
to
is signed by whom? Received?
Lordship, Principal, Lordship.
Who is this principal? Is the petitioner a principal? Attendance sheet for witnesses in connection with the department relating to the matter of Manav Deka, Associate Professor under suspension. Who are there? Samay Ranjan, Akbar, attendance sheet, Social Iman, Abhijit, inquiry report of the inquiry constituted as read. Was the petitioner present in the inquiry? Oh,
Yes, Lordship.
petitioner present in the inquiry?
Lordship. That instruction, Lordship.
Oh, that is the only instructions I've been asking for all this time. See, Mr.
My
I
lord,
recorded
regarding
on the last
my lord,
occasion.
appointment of the inquiry officer was never communicated to me.
Yes, that is what.
However, my lord, I was informed
Hmm.
on 21/2/23
Hmm.
regarding appointment of the inquiry officer, and I was told that I can inspect the documents. Then, my lord, on 21/2/23, petitioner was instructed to appear, and accordingly he appeared. And my lord, he requested for the
21?
21/2/23.
But here the date on which you are to appear, you are hereby asked to see the documents and materials on the basis of which departmental proceedings have been initiated on you. If you are willing, request you to be present on 25/2. Then another, you are hereby request to appear before the inquiry officer in connection with the
25 to
departmental.
2003, my lord. 23.
Yes.
Yes, I was there.
On 25/2/2023.
Yes, yes.
You inspected
In
some
fact,
documents.
yes, my lord. On 21/2/23, the petitioner was there. 25/2/23 also petitioner was there.
On 28/2/2023.
Petitioner, yes, yes.
So he was there in the inquiry.
I was there in the inquiry, my lord.
Hmm.
In my absence, my witnesses were examined. I was never allowed to cross-examine. My lord, this is an inquiry. If the records are called for, lordship will find lot of anomaly. My lord, with great respect, my lord, I am not on the inquiry part. For that, I'll come later on.
Hmm.
Here I am assailing the suspension order, my lord. Here what had happened,
Hmm.
I was suspended, my lord, on 25/3/2021, charge sheet was given to me.
Hmm.
Then, my lord, on 8/4/22, I was suspended.
Till that I am under suspension, there is no report. That is my case before Lord.
Now, Mr. Nath, you are the college.
Yes.
Have you intimated him about the inquiry report?
Inquiry report, the inquiry officer has completed the inquiry and submitted the thing before the director.
Understood, on 17/3/2023.
Yes, from the directorate, I am told that from the directorate, he has been communicated and he has been asked to file his reply, if any, to the inquiry report from the directorate.
My lord, it's a case where inquiry officer submits the inquiry report to the director, not to the delinquent. Until date, I have not been submitted the inquiry report.
Inquiry officer will definitely, he will submit the report to the authority only, because the.
Yes, because the authority is I think the higher education department,
Director higher education.
being the appointing authority.
Yes, he is the disciplinary
My
authority.
lord, my submission would be, my lord, at this stage, my lord, there are lot many anomalies in the inquiry report. I would not like to make any submission because I will be disclosing my defense. It will prejudice my case. Lot of anomalies are there, my lord. First, my lord, date of appointment of inquiry officer is not intimated. Of course, subsequently they intimated me. On 3 days I appeared. I have not been given the opportunity of cross-examination. My witnesses were examined behind my back. They take note of the, my lord, that initial inquiry conducted by the college. These are all going on. I have not said anything. Because why should I disclose my defense? Let them take some action. Here I'm in this petition, my lord. I'm basically against my suspension order, which is now almost 1 year old. And my lord, they must also satisfy your lordships, since the proceeding was initiated on 21/5/3/21, because the disciplinary proceeding commenced when the charge memo was given to me. Then thereafter on 8/4/22, what was the after about, my lord, about the 13 months I was placed under suspension. Until that, there is no review. I am continuing. I am on that. 25/3/21 charge memo given, then proceeding in a perfunctory manner is going on. They have also concluded the inquiry. That report will come, we'll see. Then 8/4/22 I am suspended till date, my lord. And more importantly, my lord, against the suspension order, there is a provision for appeal. I preferred an appeal, my lord. And my lord, on that appeal, the government sought a report from the director on 21/7/22. Till that, director has not given anything. If your lordship kindly comes to my lord, page 56, my lord, of the writ petition. I filed an appeal also. 56 here. Oh, 51, sorry. 51, my lord. Oh, they don't keep that. Copy.
Who is appearing for the?
My lord, sorry, my lord, this is not annexed to the document. Please have a look at this. On 21/7/22, my lord, kindly this document, my lord. Kindly see, my lord, I preferred an appeal against my suspension order. Then the government, the rights to the higher education department, with reference to the subject cited above, I'm directed to enclose it a letter along with enclosures received from Manam Deka, Associate Professor, and request you to kindly furnish Paradox report on or before 31/7 for further necessary action. Till that, my lord, director has not said anything. I did not approach this honorable straight away, my lord. I filed an appeal. I avail my statutory remedy.
Yes, Mr. What is the state of affairs as regards the director of higher education in the appeal, which has been filed before the school education department? And is the school education department being represented by you as well as the higher education department?
No, lordship, only the higher education.
Who is appearing for the school education department?
Higher education.
School education department, who is appearing?
I think, my lord, it will be higher education, not school education.
No. There is a school education.
Acha.
They have various departments. One is the higher education department, the elementary education department, secondary education department, all these. Now he is appearing for the director of higher education
Lordship,
department.
1 and 2.
And if this letter which appeal, if the suspension is being done by the disciplinary authority,
Yes,
who is the director of higher education department,
yes.
then if the appeal lies to the school education department, then doesn't make any sense.
Right.
If it is the same council representing.
No, we filed the appeal before the government.
Understood, but this is under the, this is the government is under the school education
Yes.
department. Of Education, I'm saying.
Department of Education.
Who is appearing for the Department of Education?
And what is the charge against me, my lord, on the casual leave, my lord? Because the head of the department approved it, then I avail leave. 1 day's casual leave. Even in the school education department also, if the matter pertains to higher, then the council for the higher.
Then the higher appear for both the director of higher education and as well as the education department. If it appears, then within the disciplinary authority as the and the appellate authority becomes the same.
Authorities are different, but council same law.
Then the appeal, the provision of appeal doesn't it becomes others.
Lordship, it is the commissioner and secretary, Lordship.
Understood. You see, you are the disciplinary authority.
Yes, Lordship.
You have suspended him.
The director of higher education.
He has challenged that before the authority. Now the authority, if it is represented by the same lawyer who is appearing for the director of higher education, then what remains out there? Wouldn't there be a conflict? Why I am asking you, you give a copy of this to him?
Yes.
Here the petitioner have filed an appeal before the commissioner and secretary, Department of Education. The joint secretary or the additional secretary have sought for a parawise reply. This was done as far back as on 21/7/2022. What have you done? Have you submitted the parawise reply?
Lordship, that instruction, Lordship, I'll have to obtain, Lordship, what was done after that, after receipt of this, Lordship.
Mr. Chaudhary, have you received that letter from them along with the inquiry report?
No, nothing.
Lordship,
When did you send it?
আমি inquire করতে পারি? দেখেছি, দেখেছি।
Lordship, it was submitted to him, Lordship. Lordship, I have to take instruction regarding this, whether it was forwarded to him and the Lordship, whether parawise comment was.
No, not on that. You see, he has a right to reply
Yes, Lord.
to that particular inquiry.
Yes.
He has a right to reply whatever it is. That is before the disciplinary authority takes any action. Now, does the inquiry proceedings end with the submission of the inquiry report?
Was furnished to him.
Mr. Chaudhary?
No, my lord. Now, according to the procedure, my lord, the inquiry report will be furnished to me, then I'll have a right of reply. And we do not know, supposing inquiry officer has exonerated me, let us assume, my lord, then disciplinary authority.
No, the report goes against you.
Okay, if it goes against me.
That is
then-
the problem this court is
then
facing.
I have a right of reply.
Yes, that is why. Otherwise, if it was otherwise, I would have immediately passed an order in your favor. It goes against you, but you have a right to reply.
Yes.
But if we see rule 9(9) of the,
Yes, my lord.
I think with the inquiry being submitted,
If it is not inquiring authority, consider the inquiry report is finding. If the disciplinary itself is the inquiry officer,
No, no.
then
9(9) say
yes,
the inquiry will come to an end with the report.
no, disciplinary cell, if it is not the inquiry authority. 7, I think. my lord. At the conclusion of inquiry, inquiry authority shall prepare a report of inquiry, recording its finding on each charge together with the reasons thereof.
Yes.
Now there is a
Now,
proviso, my
you
lord.
see, 9(7) says at
Yes.
the conclusion of the inquiry,
Yes.
the inquiring authority shall prepare a report of the inquiry,
Hmm.
recording its findings on each of the charges together with the reasons therefore. So, with the inquiry report, doesn't the disciplinary proceeding end?
No. As far as that inquiry which the inquiry or officer conducts, that comes to an end,
That comes to an end.
not the proceeding. Proceeding will come to an end, either it may result in a penalty or it may result in closure or whatever. Now this
No,
proviso
no,
is
it
added,
will
my
come
lord.
to a- It will come to an end as per 9(9).
Yes,
When the disciplinary authority
Yes.
takes a step.
yes.
Now, in between that, in view of the ECIL judgment.
No, my lord, there's a proviso is added now. Come to that proviso.
Yes, where?
Provided that the findings on such article of charge shall not be recorded unless government servant has either admitted the facts on which such articles or has reasonable opportunity of defending himself against. It's a proviso to 9(7), my lord.
Oh, no, 9(7) is different. Finding
This
of
is
shall not
the-
be recorded
This
unless-
is regarding the inquiry part, my lord. Then comes 8.
Yes.
Then inquiry officer will record his finding.
So 9(9) is the thing.
Yes. Then
In
the
between-
MDECI.
No. In between 9(9)
Hmm.
comes ECI.
Yes. Yes. Because there was at one point of time, because my lord, that second show cause notice was done away with by the 42nd Amendment.
Mhm.
Some court took the view that second notice is not required. Eventually, Ramzan, then MDECI.
So here you have a right to say,
Yes, 100%.
not against what charge is, not against the punishment, but as regards that you are not guilty
Yes.
of what
Yes.
has been held.
That I should be given an opportunity to persuade the disciplinary authority that inquiry officer is wrong on account of XYZ. If the inquiry officer holds against me. As I have submitted, my lord, my challenge is to the suspension order. Now, Lordship will also see from the record what was the satisfaction which was arrived at by the disciplinary authority. What was the necessity of placing me under suspension after 13 months? I can appreciate, my lord, I am suspended. Allegations are very serious. Either disciplinary proceeding is contemplated or disciplinary proceeding is pending.
Mr. Chaudhary, where is your memorandum of charge?
Yes. Memorandum of charge is at page 41.
Allegation, yes. Alien 12, so you can answer 15 and
41.
Page 41.
While you were in service as assistant professor in the Department of Physics of Prantilius College, you were unauthorizedly absent from duties and being involved in immoral activities at an outstation location on a full working day.
Wait. No. Here, it is very important is this page 41. Read it. In exercise of powers conferred by the government, the
By
undersigned
notification
hereby
dated.
asks you to so cause under Rule 9 as to why any of the penalties prescribed in clauses 1 to 3 of 7. That is a minor penalty.
Minor,
Now, why do you need his suspension for that?
exactly.
You have not put him to notice under for major penalty.
The director has done.
Huh?
Director has issued now.
So this is issued by the director.
Director.
So he says that only minor penalty, which is 1 to 3, says censure, withholding of increment, recovery for pay. Then why do you need his further suspension?
And Lordship will kindly take note of the dates. This is 21 and that is 22 April. After 13 months.
Because the allegation, the penalty you are going to impose is only 1, 2, and 3, which is a minor penalty. I would have understood if it is a case under 4, 5, 6, 7, and 8. 7. That is a case of dismissal. So why do you need his continued suspension? Let us assume that whatever you have come,
Yes,
the
correct.
inquiry report, whatever may be, you impose something which you have not asked him to. You have never asked him
No.
that we are going to impose upon him the major penalty.
Yes.
Double again.
So the suspension order has to be set aside now. You have completed your inquiry. Nothing remains.
Now
The
the
major, what are you going to impose upon him? Either you will censure him or withhold his some increment or recover some pay from him. Nothing more than that. Although the findings which you have comes within the ambit of 7, but can you do that when you have not put him to notice on that? Isn't it, Mr. Chaudhary?
Yes, yes. I think, my lord, the lordship will also take note of one more aspect. I think, my lord, some satisfaction has to be there. What impelled the authority to put me under suspension after 13 months? Is it their case that I interfered with any witness? Is it that I was trying to, influence the process of inquiry or something? Otherwise, power of suspension is not there. It can't be an automatic. It is now something, my lord, which is in the offing. Just pick it up. The director, and kindly see, my lord.
Unless you put it in the realm of a Hindi movie, that you will be suspended if you don't do this. Where is your suspension order now?
Yes. Suspension of page 50, my lord.
8/4/2022.
Yes.
Further continuation does not arise in
Yes.
view of what is the punishment. Can't help you more than that. Heard Mr. K. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner. Senior counsel assisted by Mr. R.M. Deka.
With the lordship's kind permission, can
Yes, please.
Deeply.
On behalf of respondent, on behalf of the petitioner, Mr. D. Upamanyu, Mr. D. Nath, appears on behalf of, Mr. D. Upamanyu appears on behalf of the respondent number
1 and 2.
1, 2, 1 and 2.
Yes.
Mr. D. Nath appears on behalf of the respondent number 3, 4, 5, and 6. The instant writ petition has been filed challenging the suspension order dated 8/4/2022, whereby the petitioner was suspended pending withdrawal of departmental proceedings on the basis of a resolution number 2 dated 3/3/2021 of the governing body of the Pragjyotish College, Kantipur, Guwahati 781009. On the ground of his unauthorized absence from duties and being involved in immoral activities at an outstation location on a full working day. It further appears from the records that on 25/3/2021, almost more than a year prior to the order of suspension dated 8/4/2022, the memorandum of charge was charge sheet was issued to the petitioner. From a perusal also, the charge sheet reflects the penalties which would be imposed the charge sheet reflects the penalties upon which the charge sheet reflects that in respect to penalties prescribed in clauses 1 to Roman 1 to Roman 3 of Rule 7 of the Assam Discipline Services Discipline and Appeal Rules 1964, or short, the rules of 1964. The petitioner would be inflicted upon in respect to the charges made against the charges leveled against the petitioner. A perusal of the rules, perusal of Rule 7, more particularly Rule 7.1, 7.2, and Rule 7.3 of the rules of 1964 stipulates the penalties which are likely to be imposed, stipulates the penalties. Taking into account its relevance, Rule 7.1, Rule 7, Rule 7.1, Rule 7.1, 2, and 3 is quoted herein, is reproduced herein below. It would also be relevant herein to take note of Rule 9.11. also stipulates what are minor penalties. It has been mentioned that a penalty is specified in rule in clauses Roman 1 to Roman 3 of Rule 7 of the rules of 1964 are minor penalties. Today, the Learned Counsel appearing on behalf of the Higher Education Department, pursuant to the order dated 23/2023 of this court, have produced the order by which the enquiry officer as well as the presenting officer was appointed. That is dated 13/1/2023. It further transpires from the documents which were placed that the petitioner was duly informed that on 25/2/2023 he can inspect documents, on 28/2/2023 the petitioner has to be present before the inquiry officer, and thereupon it further to the said documents, the inquiry report dated 17/3/2023 have also been placed before this court. From the inquiry report so submitted, it reveals, so submitted to the Director of Higher Education, it reveals that the charge of unauthorized absence as regards the petitioner was partially proved, and as regards the charge of involvement in immoral activities which have tarnished the image of the college as well as the teaching fraternity was fully proved. The Learned Counsel appearing on behalf of the Director of Higher Education, as well as the Learned Counsel appearing on behalf of the respondent number 3, 4, 5, and 6, have also submitted that pursuant to the inquiry report, the petitioner had been put to notice. A notice has been sent along with the inquiry report, seeking the petitioner's reply. On the other hand, the Learned Counsel for the petitioner had submitted that no such communication had been received by the petitioner as per their information. Be that as it may, one aspect of the matter is clear. That, be that as it may, it is no longer res intriga. That suspension cannot be construed to be a penalty. And such suspension is made on account of an inquiry, on account of the departmental proceedings be held without any interference. In the instant case, the departmental inquiry, the inquiry having been already submitted, and the penalty which and the penalty in respect to which the petitioner had been put to notice being only a minor penalty relating to censure or withholding of increment of promotion or recovery from pay, this court finds no reason as to why there should be further continuation of the suspension of the petitioner. Under such circumstances, this court holds that the further continuation of the suspension in terms with the order dated 8/4/2022 would be unfair and unjust as well as unreasonable, for which this court directs that the petitioner be reinstated forthwith to his post on the basis forthwith to this post upon a certified copy of the instant order be served upon a certified copy of the instant order being served upon the Director of Higher Education next. This court would further like to make it clear that the instant judgment shall not be construed in any manner as touching upon the inquiry or the inquiry proceedings, and the disciplinary authority shall be entitled to pass such orders as deem fit on the basis of the inquiry report The petitioner also, if so aggrieved by such order. No, it was- as deemed fit in accordance with law. The said observation shall also not preclude the petitioner to take such course of action as deemed fit. With the above observations, the petition stands disposed. The documents so served, so produced by the learned counsel for the higher education department is kept on record and marked with the letter S.
Offline.
Sixty-six.
Yes.
Order dated 27 March 2023, my lord. Honorable Court passed directed the PWD.
Have you got your provisional pension
No, my.
till now? You have not received it?
No, nothing.
Well. In spite of an order, 2 orders being passed,
Yes, sir.
you have not received the provisional pension. And where is the PWD? Which department is there?
PWD department, my lord.
PWD. We call for the commissioner of PWD. Heard Mr. J.U.N.M. Loskar, the learned counsel appearing on behalf of the petitioner. None appears on behalf of the PWD department as well as for the finance department. Mr. Who appears for the Dimaso?
Lord, I am appearing. C. Sharma, Lord. C. Sharma.
Mr. G. Sharma
C. Sharma,
appears.
Lord. C. Sharma.
C. Sharma appears on behalf of the Dimahaso Autonomous Council. And Mr. R.K. Talukdar appears on behalf of the Accountant General. The learned counsel appearing on behalf of the petitioner submits that in spite of the orders passed on 6/2/2023, as well as on 27/3/2023, till date, the petitioner have not received any provisional pension. Under such circumstances, this court fixes this matter again on 26th of April 2023. On which date? Who is the person responsible?
Chief engineer, my lord.
Huh?
Chief engineer, PWD department.
Chief Engineer Planning?
My lord, PWD roads and building, my lord.
Yes, Chief Engineer Planning. Have you given the provisional pension?
My lord, I have just received this, my lord, instruction, my lord. I will just go through my. I was after this.
We call the commissioner and special secretary to the government of us. Such circumstances, this court therefore calls the directs
am
the
directed to
personal
inform
appearance
the
of the
concerned
commissioner and
Yes, my
special
lord,
commissioner and special secretary to the government of Assam PWD roads to be personnel present in the court on 26th of
my
April
lord, I'm
2000.
sorry, my lord, I'm there, my lord, my lord. I bow down, my lord.
No. It is not for your presence. What about it? Have you got the provisional pension or not?
That is what, my lord, I have to get this printout when I'm placing this instruction, my lord. It's an order, my lord.
What is that?
My lord, to the accountant general, my lord, we have sent it provisional pension. That is what I'm just placing it. I'll just get a photo.
We'll take up after some time.
Lordship, in respect of provisional pension, Lordship, Accountant General has
No business.
Yes, Lordship.
Let me get this printout, my lord.
Accountant General has no business.
My lord, the order says that I am directed to convey the sanction of Governor of Assam to the grant the provisional pension of rupees this much
23,800 such only per month plus relief and medical allowances admissible to see the petitioner retired such and such retired on 31/7/21 executive engineer. But this is an order, my lord. I'll just get a printout and I'll place it with your lord.
We'll take it after some time. One minute.
Seventy-three.
Your Lordship, I'm extremely sorry, Your Lordship.
Yes.
Your Lordship, some more time may kindly be given, Your Lordship,
Why?
for doing the instruction, Your
Would
Lordship.
you like to obtain instruction as to whether the order impugned in the instant proceedings is an order under Rule 21 of the Assam Pension Service Rules?
Yes, Your Lordship. So, Your Lordship, immediately after viewing, Your Lordship.
I remember this is a matter, a hearing matter, na, which came up on that day.
Yes, whether post-conviction during pendency of appeal, he'll be entitled to provisional pension.
Ah.
That is the issue.
No, that issue as regards Rule 22 does not come into the picture.
Whether
Here,
there is an order passed under Rule 21.
yes, whether he, without passing an order under Rule 21, can he deprive you? Because in fact, the order is not an order under 22.
Yes.
This order you have put to challenge is an order under 21.
Yes, Your Lordship.
Where is that order?
At
See
page
somewhere.
22.
Where is that order, madam?
32.
Page 32. Hence, he is not entitled for pensionary benefits. This is being done by the, has to be done by the governor.
Yes, Your Lordship. Your Lordship, if the power is delegated to, then Your Lordship, any officer can pass this order if it is delegated.
Delegated of what power?
Of the governor's power.
The governor has given his power.
Your Lordship, because the under Rule 21, it is empowered the governor to withhold the pension. You know.
Huh?
Pension.
Power is being given, can be delegated.
Your Lordship, we'll have to see, Your Lordship, whether it is delegated or not.
Huh? I don't know. The power under 67 is delegated, but whether the power under 21 is delegated.
Your Lordship,
you see the order, Rule 21 starts. The
Yes, sir.
governor of Assam reserves to himself the right of withholding or withdrawing a pension for a specified period of so and so of any pecuniary loss if in the departmental so and so, so and so, so and so. Where is the power of the delegation?
Your Lordship, the governor can delegate its power because they.
Isn't this an essential function?
Say executive power, Your Lordship.
No, this is not a, this is a statutory power. You see, normally reserves to himself. See the language, reserves to himself. He has the power. So what is being done? In the name of the governor, it is being done.
Yes. Yes. Your Lordship,
Tomorrow,
Yes.
are you going to issue an amendment to a statutory rule by yourself, by your department? No, it has to be in the name of the governor. This also has to be in the name of the governor. It's not a matter. That is why 21 is such a, it's a precious right to get a pension. And you can't just take it away by your departmental officials at your sweet will.
And it has to be reflected in their order.
Now see Rule 67. See Rule 66A, B, page 38 of that book. The governor may, subject to such conditions as he may think fit to impose, delegate power under this rule to an authority to condone the interruption. When an act or a rule categorically defines out there where the governor can and where the government cannot, and there is no mention, it will be deemed that it has to be exercised by the governor.
Your Lordship, this point, Your Lordship, I would like to refer to decision, Your Lordship.
What
of the
decision?
Honorable Supreme Court. Your Lordship.
What does it say?
Yeah, in this matter, Your Lordship, facts is that he is a retired person. After retirement, any departmental proceeding to be initiated under prior approval from the president or the governor. Your Lordship. Here the president. Your Lordship, here the paragraph 12, Your Lordship, I am referring to the decision. Paragraph 12, Your Lordship.
What does it say?
It says, even where an order is issued by Secretary of the Government without indicating that it is by order of the central government or by order of the President, this court came to the conclusion that immunity in Article 166(2) would be available if it appears from other material that in fact the decision had been taken by the government. Paragraph 12. Your Lordship.
You see paragraph 13.
Yes, Your
That
Lordship.
being the position and the order initiating the departmental proceedings having been signed by the undersecretary to the government by order of the governor. So where is that? I'm not asking you to pass that the governor needs to sign here. No,
Yes, yes, yes.
it has to be under
In
the
the name of
orders
the
of the governor.
Yes,
Do you find any notification where the governor is signing? No, it is always done in
Yes,
the
it
name
is.
of the governor.
Yes,
That is the power which is to be done under, this is a valuable right.
Yes.
A person's pension you are taking away. So the governor, it has to be in the name of the governor.
Your Lordship, the paragraph 12 says
Paragraph
it is
12
not
has
always
to be
required.
read with that. Show me the materials, other materials. That is why I wanted to see
Yes,
the
Your Lordship.
records.
That is why, Your Lordship,
Then,
I am praying for some more time. Your Lordship.
then why you are showing the judgment? She has not received the pension for a long time. When? It's a short matter. You are only to show me that document.
Yes, Your Lordship. Immediately
Then?
after Bihu, Your Lordship,
Very well.
on 20 or
20.
Partha,
Why Pathot? I may not be here.
Lordship, Lordship, the last order already reflects that it's heard at length.
Heard at length, all my matters are heard at length. That is why I don't finish up all matters. Anyways, let's see.
on 21st, Your Lordship, 21.
21.
Lordship, the impugn order, if there had been a order by the governor, these order would have reflected it because
That is what
generally
I'm
the
saying.
Orders start with
That is what I'm saying. That is why I want to see the records because of that. You see that paragraph 12.
Yes, sir.
From other materials,
Other
can
materials
you
will be
show that?
Yes.
That yes, the governor's here has been taken. If it is not done, then you can't.
Lordship, in all probability, there is nothing because
I
that
know
is why
that
this
there is
judgment took
nothing.
place.
I
That is
know
why-
that there is
That is
nothing.
why this judgment took place.
Yes, but then also heard Ms. D. Borgohai, the learned counsel appearing on behalf of the petitioner, and Mr. K. Kaur, the learned counsel appearing on behalf of the PNRD department. This court by the order dated 3/4/2023 had directed the PNRD department to obtain instruction as to whether the order impugned in the instant proceedings is an order under Rule 21 of the Assam Service Pension Rules 1969. The learned counsel appearing on behalf of the PNRD department seeks an accommodation to produce the records on the next date so fixed by this court. List the matter on 2023.
21,
21,
21, Friday, 21st.
Friday may be closed if the moon comes out.
Let it be on 20,
Then
on the
when-
next,
20.
next week.
We'll have it on 20.
On 26, then you will.
No.
I'll go by your lordship convenience.
We'll have it on 20.
20.
On 24, 2023.
Obliged.
I'm coming. Art Mr. J.U.N. Loskar, the learned counsel for the petitioner. Mr. R. Dhar appears for the PWD department. And Mr. R. Borpuzari appears for the finance department. Mr. C. Sharma appears on behalf of the Dimahasa Autonomous Council. And Mr. R. K. Taluka appears for the Accountant General. It has been brought to the attention of the court that the petitioners, that the respondent authority have already sanctioned the provisional pension of rupees 23,868 to be paid to the petitioner with effect from 1/8/2021 till the final pension payment order is issued by the Accountant General AE as per the It has been further mentioned that the Executive Engineer PWRD, Lakhipur Civil Subdivision, Territorial Road Division, Lakhipur, Kachar, has been requested to draw and disburse the monthly provisional pension plus relief and medical allowances to the petitioner with effect from 1/8/2021 till the final PPO is issued. Copy of the same have also been issued to the Treasury Officer, Lakhipur Subdivision. The copy of the said communication is kept on record and marked the letter X. Taking into account the same, the Treasury Officer, who will disburse? Treasury Officer. The Treasury Officer, Lakhipur Sub-Treasury, is directed to disburse the Executive Engineer, PWRD, Lakhipur Civil Subdivision, Territorial Road Division, as well as the Treasury Officer, Lakhipur Sub-Treasury, are directed to do the needful in terms with the order dated 1st of April 2023, so that the petitioner receives his provisional pension. As regards the final pension, Accountant General,
They have to forward the complete and correct document.
the learned counsel, the matter, the instant matter is again fixed on 24th of May 2023, on which date the learned counsel appearing on behalf of the PWD department, PWD, as well as the Learned Counsel appearing on behalf of the Accountant General AE shall apprise this court as regards the status of the pension as well as the pensionary benefit, other pensionary benefits to which the petitioner is entitled to.
My lord, one clarification, I'm sorry, my lord. My lord, this provisional pension, it has to be disbursed by the executive engineer. It
I've
is-
mentioned it.
Yeah, my lord, now the treasury officer has no role. It is the
Okay.
executive engineer.
Remove the treasury.
My lord, it is there. Executive engineer so and so, he is requested to
I've given
draw
that.
and disburse.
And the treasury officer to do the needful has been mentioned, na? Treasury officer, remove the treasury officer.
At this stage, I do not have any jurisdiction, man. Yeah, right.
76,
মোৰ এই credit method টো লগাব লাগে ন, এইটো hearing আধা বেছি হ'ল। Yes, Mr. B. Gogoi.
Lordship, there is budget allocation, Lordship. It is available under the head of accounts of for the financial year 23 and 24.
To which petitioner has claimed to
Lordship,
be
however,
entitled, there has been a
the
budget, however, he would like to take on which is the document we furnished with. Yes. So you have already paid the petitioner 1,05,479.
Yes, Lordship.
And the remaining 1,83,584.
Yes.
You have not paid on account of non-budgetary allocation.
Yes, Lordship. But now, Lordship, it is available. But the proposal, Lordship, will have to be submitted by to the government immediately after receipt of the budget communication.
Who is to submit the proposal?
Yes, Lordship.
Who will submit the proposal?
Lordship, the Director of Health Services.
To
the Lordship Commissioner and Secretary Health Department, Lordship.
So it is all within you.
Yes, Lordship.
Then why haven't you done that?
Lordship, will be receiving it, Lordship, within a week or two, Lordship.
Then?
It was supposed to be received by 10th, Lordship, but it was not received, Lordship. But within a week, Lordship, it will be received and we'll move it, Lordship.
We'll have it on 3rd of May.
Yes, Lordship.
I hope he gets the money.
Yes, Lordship.
Mr. A. Sharma, the Learned Counsel, appearing on behalf of the petitioner. Mr. D. Upamanyu appears on behalf of the Health Department. Mr. A. Hassan appears on behalf of the Accountant General AE. Does the finance there?
Yes.
And Mr. R. Bofidari appears on behalf of the finance. It has been brought to the attention of this court by the Standing Council for the Health and Family Welfare Department that an amount of rupees 1,05,479 have already been paid to the petitioner on 28/2/2023.
28/2/2020.
I'm sorry.
As regards the amount of rupees 1,83,564, the same is in the process of being made upon receiving the budget allocation. The Learned Counsel for the Standing Council for the Health Department submits that the budget allocation as per his instructions is now available and the said amount will be disbursed very soon. Lists the matter again on 3rd of May 2023, on which date the Learned Counsel for the parties shall apprise this court as regards as to whether the amount of rupees 1,83,564 has been disbursed to the petition. The instructions so submitted by the Learned Counsel appearing on behalf of the Health and Family Welfare Department is kept on record and after the lecture.
Highly.
Obliged.
80.
Your Lordship, can we peruse the last order, my lord? The order dated 24/3/2023. The penultimate paragraph, my lord.
Yes, Mr. Barbadari.
But I have received the instruction, my lord,
Mm,
just a while ago, my lord, in my WhatsApp,
mm,
my lord, from the office of the Treasury Officer, Tihu Sub Treasury.
mm.
My lord, they have sent one half of the PPO, my lord, on 28th of March, last 28th of March by speed post, my lord, to the Director of Pension. Now, the second half of the PPO is lying with, my lord, the petitioner. Either the petitioner or, my lord, the private respondent who is, my lord, drawing that pension. Because the Treasury Office, Tihu, my lord, have only control over the PPO that is available in the State Bank. And from the State Bank, my lord, that PPO has been taken and, my lord, it has been disbursed to the Director of Pension. And it was sent through speed post, my lord, on 29th.
So somebody, are you saying that somebody is receiving the pension?
Yes, my lord.
Huh?
Yes, the private respondent.
Is receiving the pension?
No, it is the admitted case out here.
And private respondent happens to be?
My lord, the
My lord.
second wife.
Respondent number 11. She is the second wife.
She is the second wife.
And how can the second half be there with the private respondent?
No, because she had represented at earlier one point of time, my lord, that she is the legal heir, and there was a nomination, my lord, in favor of the second wife. So the second wife was drawing pension, my lord. She was doing 100% pension. First wife, my lord, moved this honorable court by writ petition in the earlier round of litigation.
Hmm.
The earlier round, my lord, this honorable court had dictated, my lord, directed the authorities, my lord, that both the wives will be entitled to 50% of the pension.
Hmm.
And that has not been, my lord, complied into. So therefore, this is the, my lord, present writ petition pending before this honorable court. Now, to, my lord, to act upon on the basis of that order passed by this honorable court in the earlier round of the writ petition, both half of the my lord, PPOs have to be, my lord, furnished to the Director of Pension so that he will work out. Then a fresh PPO will be issued. To that extent, my lord, this authority, my lord, the Treasury Officer Tihu, the PPO available because both half is not available in the Treasury. One half is written, my lord, the one who is drawing, my lord, the pension. And one half is written in the, my lord, bank account, that is SBI. And whatever is available with the SBI, my lord, that has been taken, my lord, by the office of the Treasury Officer Tihu, and that has been disbursed to the Director of Pension. And the second half, my lord, in all probability, it is, my lord, lying with the private respondent. And over that, my lord, the Treasury Officer has no control. It is see, we will have to.
That is correct.
No. When there is a direction to pay 50%, why haven't you done anything all this while from 2019 onwards? Why is it still lying? Why have you not stopped the pension of the private respondent? Then obviously things will improve. There is a specific direction for paying 50%. Now, if it is a 50% is to be paid, now tell me one thing, if 50% is to be paid to the petitioner and to the private respondent, obviously one will have the half. Now here the private respondent is having the half, one half, and private, and one half is being sent by the Treasury Office. So then why you are not apportioning as to 50-50? That is the direction passed by the court earlier.
Yes, and for that purpose.
So just
also,
for example, let us take the converse situation. Here the petitioner has half. And the petitioner is not willing to give. Are you not going to give the 50% to the other side? There's a direction passed in the year 2019 for paying 50-50. So you have to apportion only. Do the needful so that the petitioner gets 50% and the 50% is being given to the other side. What steps have been taken all this while? Or are you paying the 100% to the private respondent? Wouldn't that be a violation of the court's order?
Got the concrete instruction in this matter. Lordship. One instruction that we have asked the PPO, half of the PPO from the treasury officer. That instruction only I have.
You got the
to the
treasury
place-
officer half. The other half is there. So if you want the other half, you stop the pension or immediately the other half will to come in. Have you written a communication to that effect? No. 4 years the petitioner has been deprived. Or are you paying the 100%? Is the treasury officer disbursing 100% to the respondent number 11?
No, after this order, no.
No, then why you are keeping the 50% to yourself? On one hand, you stop it. Very well. Who is going to appropriate the remaining 50%? It is for the petitioner to be appropriated with that amount. Then this half or that half, all these are technical aspects of the matter. You want to correct it or issue some separately in terms with the order which has been passed earlier. Now you have the power in terms with note D, note 2D, you have the power to that, exercise it. When the power is being given, earlier 50% was not the power. Now you have the power. Apportion it. Pass an order to the effect. Say that 50% he will get, 50% she will get. At the end. Well.
After 3 weeks, Lordship, I will apprise that your Lordship about the present status.
10th of May.
10th of May.
It is more than 3 weeks. You are asking for 3 weeks. I gave you more. Heard Mr. A.K. Borua, the learned counsel, appearing on behalf of the petitioner. Mr. S.R. Borua appears on behalf of the Director of Pension. And Mr. R. Pudari appears on behalf of the Finance Department as well as the Treasury Officer.
Only treasury.
Finance Department not a party.
PO. Only treasury is implicated as a party respondent. R7.
How many people have made parties with the okay. One appears on behalf of the respondent number 7, the Treasury Officer.
I'm for respondent number 9. Respondent number 9.
The here respondent number appears for respondent number 9. UCO Bank.
I'm appearing on that.
And so appears for you give your name for respondent number 10.
Service
Anybody 11?
Service is complete, my lord. Office note dated 10/4/2023 indicates that the service is complete. On private respondent number 11, office note dated 10/4/2023, read with flags P and Q, my lord. It indicates that the service on the private respondent number 11 is complete.
It further appears from the records.
Office note dated 10/4/2023, read with flags P and Q.
And it that an affidavit of service have been filed by the petitioner, thereby affecting service upon the respondent number 9 and 11, taking into account the same.
In the blue file, my lord, like P and Q. The second file, my lord.
The service upon the respondent number 9 and 11 be deemed to be complete. Where is it?
There's a blue file, my lord, below that second file, my lord. Like PNQ, my lord. To Jarikar office note dated 10/4/2023, my lord. PNQ, like
just right earlier, it further appears on record that the service upon the respondent number 9 and 11 has been duly affected upon. Mr. R. Babujari, the learned counsel appearing on behalf of the Treasury Officer T, who submits that one half of the PPO
my lord,
have
which is-
already been furnished to the Director of Pension for doing the needful. He further submits that as per his instruction, the other half is lying with the respondent number 11. This court, upon hearing the matter, had put a specific query upon the learned counsel for the Director of Pension as to why, in spite of the order dated 30/10/2019 in deputation number 2161 of the 2018, the petitioner there has been no modification to the PPO. Though the respondent authorities have only paid 50% of the pension to the respondent number 11, first vintage. The learned counsel appearing on behalf of the pension, but the Director of Pensions submits that he would require instructions in the meantime. Let the matter be listed again on 10th of May, on which date the respondent shall update the learned counsel for the Director of Pension shall apprise this court as regards the steps being taken by the Director of Pension in pursuance to the order dated 3/10/2019 in deputation number 2161 of 2018, as well as the orders passed herein in the instance.
Obliged, deeply obliged.
Series item 32 to 64 at 78.
There's affidavit file.
No.
Okay.
And we have made, my lord,
don't think so.
several communications, my lord, to the department. One development in the matter, my lord, in between, my lord, in the meantime, my lord, this PIL Suomoto 10 of 2018.
Yeah.
That came up before the Honorable Division Bench, my lord, on 6/4/2023. The Honorable Division Bench has passed an order, my lord, Lordship may kindly use it.
What is that?
Is there, I think, Lord.
So may kindly peruse that order dated 6/4/2023. My lord, in that Suomoto PIL.
What is this LGB? Test hospital?
My lord, this is with regard to this particular DAG number 97.
So
Now here
what other orders are being passed by this court in the PL?
the other order, because my lord, what has happened, lordship has, my lord, on the last occasion, seen almost all the orders passed by the division bench, my lord, in encroachment matters. Whereby, my lord, the division bench, my lord, had not given any leeway to the petitioners, and thereby, my lord, rejecting their claim, my lord, that you cannot occupy government land. You are in wrongful occupation. But apart from all those orders, only this order, my lord, that 6/2/2023, that had drawn my lord's attention on the last occasion. And that order 6/2/2023
By the division bench,
by the division bench in this PL was passed.
wherein it says that a notice has been given.
Notices, everything, my lord, it was a long drawn order, my lord, everything.
That order has not been touched by the division bench.
So
The
that-
PL is still
Yes,
pending.
yes, PIL is with regard to, my lord, encroachment of government land in the greater area of the district of Kamrup Metro. And from time to time, this honorable division bench, from time to time, is issuing a writ of continuing mandamus. And this is one such instance. From time to time, my lord, that circle officers' reports are being called for almost in each and every date of listing this case, my lord. The circle officers are filing status report. What action they have taken. Now, everything was going, my lord, in that manner, my lord, on a prima facie view that has emerged from this PIL, my lord, is that my lord, nobody has a vested right to occupy government land. But in between this order 6/2/2023 was somewhat different. There, my lord, the division
But the
bench,
division bench have not touched it.
no, they are in 6/2/2023.
I don't understand what it meant by that some of the reporters after receiving a so have filed a petition before the learned single bench wherein order happening. We expect that Ms. Portloy will bring to the notice of the learned single bench the directions given by the division bench in this PL.
Yeah,
Meaning the direction is only there in 6-2.
6/2/2023, but earlier directions were also there.
Understood, but
Yeah.
6-2 is the subsequent order.
6/2 is a subsequent order, but
Then we dispose it as per 6-2.
6/2, yes, because 6/2 order is somewhat different. 6/2 say
So that is the last the effective order.
yeah, because
This is here when it says that we expect that so and so will bring to the notice of the learned single bench the directions given by the division bench in this PL petition.
absolutely
The
correct.
last of such order is of 6-2.
6/2. Now 6/2,
Is it when it is a reference being made to 6-2, unless you go for a full bench or a different bench, 6-2 takes the first.
6/2 it is there, of course, but they are in that PIL, my lord. Apart from this particular DAG number 97, which is the subject matter of the present list.
Not only 97, there are many
Yes,
other.
my lord, area of plot of land reserved for TB hospital, my lord, second hospital, medical college and hospital. There are other lands, government lands. Some has been, my lord, encroached by some religious institutions. Some have been encroached by local educational institution. Now this division bench in this Kumamoto PIL is issuing, my lord, orders that you remove encroachment. This is the, my lord, chain of orders. This is the continuity of sequence of orders. My lord, no way 7 except 6/2/2023.
But 6-2 is the last.
6-2 is the last order,
And the
but,
division bench, after taking into consideration the earlier orders, have passed 6-2.
but what had transpired before the division bench, my lord, since I was also there, my lord, on 6/4/2023, division bench said that no, nothing doing. So you have to, authorities will have to do the needful for making the government lands encroachment free. That's all. No leeway, nothing. This is what come up, my lord. This was, my lord, the mind expressed by the Honorable Chief Justice. I'm submitting with all my lord responsibility.
But the Chief Justice has, if it's taken, that it can't be the Chief Justice, it has to be the division bench.
I am submitting, my lord, what had transpired in the
It has
court.
to be by the division bench.
Absolutely, Lordship is correct. Lordship may take a view, my lord. Lordship may take any view of the matter, my lord, keeping in mind the pendency of this PIL, whether Lordship is going to give any leeway to them or not.
No, if I have to take the leeway, I have to only take 6-2.
6-2 it is there, but
But the
then again-
division bench also said that taking into account the orders which have been passed out,
no, taking into account of the orders, my lord, it doesn't specifically say of 6-2.
the last of the order
The
is
last of
6-2.
the last of the
Then-
order is 6-2. But my
then-
submission will be that, my lord, that the prima facie, my lord, view of the Honorable Division Bench is that, my lord, the authorities,
But has the division bench taken into consideration a very relevant aspect? You see, Radha Kanu was a judgment which was delivered at a time prior to 1997. I mean, at that point of time, 1997 amendment, prior to 1997 amendment, it was only those lands which under no circumstances could have been given for settlement. Very well. Now, does the government give settlement now, or have they stopped settlement?
settlement is still there.
See,
Government is lending settlement.
What lands are you settling?
Lands are being settled, my lord.
What land?
My lord. Some government land, my lord.
What land? Which land?
Westland, definitely.
Nothing else.
Yes, because rules say it is Westland. Westland means government land.
Maybe, but wasteland.
Yes.
Only wasteland.
Yes.
Now, if it is earlier, prior to 1997, those lands couldn't have been settled.
Yes.
Grazing grounds, all these lands, under no circumstances could have been settled. It could only be, only wastelands are to be settled, which came only after in 1997 this amendment has been. Now, can you apply Radha Kanu judgment out here? And Radha Kanu is by 2 judges.
Radha Kanu is by 2 judges.
What about Menoka Gandhi? Constitution bench.
So that is true, but the rule 17 is clear because Radha Kanu has taken a note of my lord, rule 16. Rule 16 still stands.
Understood. Radha Kanu had taken into account rule 16,
Yes.
17, 18. Let us assume everything.
Yes.
But there is no scope of natural justice.
Yes, no scope of natural justice.
Can it be
Even
done so when you settle wasteland?
now, Lordship will kindly recollect my lord.
Understood. If the government says that we don't settle any wasteland, it is a different thing. Our settlement is over. We don't settle because the government can only settle wasteland.
Yes, that is my lord government's land.
Now, an action of an authority, an administrative order can be very well challenged on the ground of violating Article 14. And Article 14 brings within it the fold of principles of natural justice. It brings within the ambit the principle of proportionality.
Yes.
Proportionality.
Yes.
Unless you show that yes, this is the land which we are required, why should an administrative authority should exercise a power? That too when you are having a specific act for throwing them out. Land grabbing?
No, land grabbing act is also there, but my lord.
And is this the land? You have allotted the land to the health department?
Yes.
Can you say it to be a land of the revenue department?
No.
Then can you exercise the power under 18?
It is allotted, not settled. It is allotted. So
That is
allotment
what-
is always, no,
The
allotment.
moment it is allotted,
Yes,
you kindly see the definition of wasteland,
yes,
the lease grant. Or
Yes.
otherwise,
yes, it is lease. Lease means settlement.
that is why
Yes, but in case of allotment, lordship will find in the record of
Understood.
right.
if it is a land or which is lease grant, see grant or otherwise. This is being given to the health department. How can you bring within it the fold of a wasteland?
So it is given to the health department. It is allotted, but the character of the land is still the government land. It is still wasteland.
Cannot be a wasteland because you see the
Yes, because of the
definition of
fact- yes,
wasteland.
Yes, yes, I will submit. I will submit. Yes, because
The
of the,
definition of wasteland is clear. The government has not disposed of by lease, grant or otherwise. Who can dispose of? It's only the revenue department can dispose of.
no, lordship will kindly
No,
mark.
no.
Yes.
Just for example,
Yes,
let us assume the land out here, the GMC land, which is there. Can a settlement be made of a GMC land by the revenue authority? No. It has to be transferred by the revenue, by the GMC, because it has now been allotted to the GMC.
Yes.
It cannot be done. It cannot be a wasteland. Then how are you exercising the power under 18?
no, well, my lord, here, my lord, if wasteland, I'm going by the definition. 1 second, for my satisfaction. Wasteland means land at the disposal of the government, which the government has not disposed of by lease. By lease, that is, my lord, settlement, grant or otherwise,
Grant or otherwise.
or otherwise.
The grant is being given to the TB hospital.
So it is, my lord, my submission will be.
It can't be a government land.
No, no,
Any
my
further?
Lordship may require, my lord, with all respect. My submission is, my lord, in the record of right, in the Jamabandi, because for government land, there is no Jamabandi. Here, lordship will find, in fact, in the requisitions also, they have annexed the documents, the chita. The government lands are always, my lord, mentioned and inscripted in the chita. It doesn't come within the ambit of the record of right, because it is not a patta land. It is not settled. So therefore, in the chita, lordship will find the entries where it is made, and that it is allotted in the name of so and so. And the, my lord, the nature of the land, it is stated, my lord, in the notes. Notes, my lord, will find tuka.
The allotment has happened.
No, lord, my lord, I am submitting that in notes, lordship will find it is still government land.
Understood.
Yes.
But maybe government land, but it has been allotted.
Allotment is conditional, my lord. So I am the government, I have the authority over the land.
Very well. You have the authority over the land, but the land has been given to the TB hospital.
Land has been given to the TB hospital. It is
Once
my
the land has been
No,
given to the TB hospital, now tell me, can the revenue authority allot the land? Just for example, which you are doing it, that's a different aspect of the matter. But can we allot the land?
Allotment per se is not, my lord, to be found in the land revenue regulation. Land revenue regulation doesn't speak for allotment. It only says settlement.
If it is not there,
Yeah.
then
So
this
it is
grant,
so therefore allotment
so
is
the
conditional.
grant is what?
My lord.
It's a grant
No, grant is grant.
or otherwise. How, what do you mean by the word otherwise?
Otherwise, then, my lord, I will have to, my lord,
Then?
satisfy my lord with some more
Then
material.
how can it be a wasteland?
No, it still remains the wasteland because it is.
It can't be a wasteland.
No, my lord.
Are you saying that all government lands,
Yes.
even the land which is in the dispute secretary, is a wasteland?
So it is allotted, my lord.
Then?
So once it is, no, allotment is always conditional.
No, do you need that? How have you allotted the land?
Allotted the land to the government department
How?
by way of, my lord, administrative action.
So here you have allotted to the TB hospital.
Yes.
Then, once it has been allotted, can you take it over again? No.
No, here lordship will kindly see, my lord, it is the exercise the government has undertaken is to make
No,
the
the
land
simple
encroachment-
question is this.
No, my lord, the encroachment free. We are doing the exercise to make the land encroachment free.
Understood. Which lands can you do it by exercising 18? Only wasteland.
Yes.
But if it is not a wasteland, then
No, 18.2 doesn't speak of only wasteland. It is also stated government khas land. Kindly see the language, my lord.
Yes.
18.2.
yeah.
So therefore, my lord,
Ah,
18.2.
which one?
18.2.
Hmm.
When such person has entered into possession
Hmm.
of government khas land.
Hmm.
Now that was inserted, my lord, in the year 1997 by that amendment. Or wasteland
Hmm.
or estate over which no person has acquired the right of a proprietor,
Hmm.
landholder or settlement holder.
That has been,
Yes, the land that has previously been reserved for roads or roadside land or for grazing of cattle or for other public purposes.
Hmm.
So this hospital will come for other public purposes or has entered into possession
no,
of land.
or any land that has been previously removed. This cannot be settled.
No, yes, yes.
Or any other land has been previously reserved cannot be settled. No
Cannot be-
problem with this.
Yes.
But can you say government khas land to be wasteland? No. Obviously no.
Yes.
Now what is government khas land?
Government
defined.
trusted, my lord, it is the land which stands in the name of the government in the, my lord, revenue record.
Where are you getting it from?
My lord, I'm, my lord, making this submission from this, my lord, rule 18 to
No, are you getting that government khas land means that land?
government trusted, my lord, is evident from the record, my lord.
No. How are you saying that? Records may say many things.
Yes,
There are many aspects of the matter which the record will say.
yes.
But can you say that it to be a government khas land means there has to be something like a wasteland has been defined?
Yes.
Has the government khas land been defined out here
No,
in the rules?
no.
Then what is the government khas land?
My lord, my submission will be, my lord, the land belonging to the government. Because lordship here will kindly.
Your submission?
Yes. My submission. I may have to satisfy with lord, my lord, with materials, my lord.
Because the concept of what is a government khas land.
Here, lordship.
Now,
will
does the rules, the act, the regulation, the rules, or any of that, even the records, the record manual, there is another, na?
Yes,
There's
yes.
another,
Yes, Assam Land
what
Record
is that
Manual.
called? This act. This Assam assessment of revenue free estate, this Assam assessment and reassessment of that is the Assam Revenue Reassessment Act 1936, Assam Revenue Reassessment Rule. All these things,
Yes,
do they define
1936
government
Act is
khas
there,
land?
1936 Act is there, 1948 Act is there.
Do they define government khas land?
I'm checking it.
No. Concept of government khas land is not there.
Yes.
Because it was all along wasteland.
Yes.
You thought about this government khas land now when you bring this without including out there in the rules. You should have brought in while defining this.
I cannot travel beyond what is there in the statute, my lord.
Where do you bring in government khas land? And it is this land where they have a right to be settled. Then why no natural justice?
No, they don't have any right to be settled with.
Yes, you have your policy.
No, I have a policy, my lord.
Then
We
that
have a
policy
That is
gives
at the
them a
discretion.
right to
No.
be settled.
So there is no vested right.
Huh?
There is no vested right.
There is no vested right, but they may not have a vested right to be settled,
Yes.
but they have a legitimate expectation to be considered.
Yes. Now,
So
now-
that legitimate expectation gives them the right of natural justice, principles of natural justice.
principles of natural justice.
Then
that's
why
true.
not? Why do 18.2 will take
Then
you take over the
Right.
entire field?
Correct. Correct.
Yeah.
Legitimate expectation in my
Maneka Gandhi 10.5 was never challenged.
My lord.
Maneka Gandhi 10.5 of the Passport Act was never challenged.
Yes.
Then also it was taken in.
Yes, correct. But
That whenever you
legitimate-
see that an administrative action is being taken,
Yeah.
it has to comply
No quarrel, my lord.
in view of Article 13.
But legitimate expectation to what extent can be made enforceable, my lord, in a proceeding under 226?
How? Legitimate expectation is not enforceable, but it has the right to be considered.
Yes.
They have a right to be considered. How can they have a right to be considered unless there is a hearing?
That is, of course, one
There the
aspect of the
principle,
matter. But
principles come in.
Yes, now, my lord, the pronouncement of this honorable court in, my lord, encroachment matters, my lord, per se is that, my lord.
That is what I gave you the opportunity to come up, but no, the revenue department is clear. We are going to throw these petitioners out and give it allotment to the old people.
No, that is not
That is
discernible.
clear because of the other at page 83.
No, page 83, only 2%. No.
This is
only two.
This
no,
is
two-
only
2%.
an ongoing process.
No, my lord, Lordship will kindly appreciate, my lord, only 2%
Why,
were settled.
why these 2%? I don't understand. Why these 2%?
At one point of time, now, my lord, that exercise has been held back, my lord. It
Which
was, my lord, some exercise was undertaken, that because in the
Even after your meeting, wherein you held that we are having the second medical college, then also you have taken that exercise.
no, that exercise is now, my lord, called back. That exercise is now called back.
That is what we wanted to put it on you on affidavit, which you have denied to do
No,
so.
my lord, the medical, my lord, health department is not a party. I am the revenue department, my lord. I have written communications, my lord. We are pursuing with the medical,
No,
my lord,
no.
health department.
That means the health department does not want to take it.
But that I
You
cannot-
are burdening them in the name of the health department. You are trying to throw them out. Then how do you bring in the concept of proportionality?
Yeah, but
And if the proportionality is not there, then it will be unreasonable.
because I, my lord, that health department.
Mr.
is-
Dhar,
health
I've given you
department is not a
enough
party.
fodder to argue in the division bench. Okay,
Lordship is
I am
already
placing
hard
these
in
matters
Lordship
before the
will pass-
division bench.
Lordship will pass the
Lordship
will pass the order.
No, I place it before the division bench because my conscience does not permit. Because I would, if I have to pass an order, I would have passed it in your favor on this basis.
In the light
But
of this,
whatever may be, let the matter be placed before the division bench in view of what the Chief Justice have said.
No, my lord.
on the basis of 6-2 Lordship, 6-2 order judgment Lordship. Lordship may pass.
Understood. Let the Chief Justice pass this.
Yes,
I'm
Lordship
not
has
going to
heard
pass.
it at length, Lord.
What is that?
No, that Silsaku order. Silsaku, in my lord, Silsaku, the authorities had undertaken eviction process. And there this honorable court has not interfered. There also, my lord, no notice, nothing. Nothing was given, my lord. No notice, nothing. Court said that you
This
have all
court
the.
doesn't interfere. Does it mean that this court would not interfere?
18-2
There
notice.
are many it depends on perspective to perspective.
I'm not on that, my
Person,
lord.
those are persons who may not be having this permanent houses. Madam's
they
house is
had-
3-storied.
No, they have.
Three-storied.
They are also.
You
they
have
had.
given permission to construct a
My lord,
3-storied
all-
also.
With all humility and
Mm.
respect, my lord, I am placing that judgment, my lord, for my lord's perusal, my lord. With all humility and respect, Lordship will kindly consider.
No.
Yes.
The court did not touch it on the ground that 18-2 is not challenged.
Yeah.
Then it is required. Isn't 18-2 a part of law within the ambit of Article 13? And doesn't it have to conform to Article 14?
No.
And if it has to conform to Article 14, your action has to be taken or has to be measured on the basis of Article 14. And if their natural justice is being violated, then why not?
No, my lord, what I am trying to submit, here is a case where some notices were given, eviction notices.
No, all of them were.
Yes, all of them. They were submitted eviction notices. In this matter, my lord, where the eviction drive has carried on, my lord, my lord, unsubmitted kindly. When there was
Mr.
not a
Bordinary,
notice even, not
If
no
this matter
notice.
would have, if that matter would have come before this court, I would have put the same question again.
In advance, my lord, my duty is to plead, my lord. I am pleading, my lord. I am placing
On
this.
the basis of 6-2 order.
Yeah, coordinate bench maybe, but if the coordinate bench have
therefore I
not
am
taken
submitting
into
my lord with
account
all
the
respect
principles
and-
of natural justice, the
Definitely,
constitution
Lordship
bench
may differ,
judgments
Lordship may
which
differ,
are there.
Yes, Lordship may differ, my lord.
Yeah, The Constitution bench judgments which categorically says that every administrative action has to have to follow the principles of natural justice. Did the coordinate bench take into action that you have come up with an act of land grabbing, which is a later part of the act? The prior act does not have the concept of natural justice. They have no right to say. Whereas in the second act, you have a right of say. Definitely, this court can very well direct that you should take up action under that, irrespective of 18 being there or not.
Now, this
Didn't the Supreme Court say in the case of that case where PMLA case said, yes, there are two conditions for put out there 14, which is 45, which is parameter to 37 of the NDPS Act. It says that these are the two conditions which are there. But then also the Supreme Court said that subsequently in 2016, 436A has come in. And as such, the acts of 1985 NDPS as well as the Act of PMLA 2002 will be bound by the provisions of the later act. Well, this is fodder for you, for the division bench. Mr. Adhar. All your names? So and so, so and so, so and so. Give your name, sir. And a counsel for the petition. And Mr. Arbor Pujari appears on behalf of the finance, on the revenue department. It has been brought to the attention of this court that on 6/4/2023, the division bench of this court in PIL Sumoto number 10/2018 had observed that notice be brought to the notice, that this court be that it is required to be brought to the notice of this court about the pendency of PIL Sumoto number 10/2018 and the orders passed therein. Taking into account the same, this court deems it proper for the interest of justice that all these petitions be placed before the division bench and listed along with PIL Sumoto number 10/2018 on 29/5/2023. List according.
I'm so obliged, my lord.
We are expecting a order from your lordship.
No, it won't be proper. But if this court was to pass the order, if that order was not there, I would have passed.
With all humility, my lord, I cannot tell, my lord, beyond. I'm so obliged.
I know 16.
Yes, madam.
Lordship, I placed the instruction, your lordship.
This is for some recovery, huh?
Lordship, access royal, your lordship.
Then what are you doing? Means have you recovered? No.
Lordship, no, we have not recovered.
There is a stay order.
Lordship,
Shall
because-
not recover the excess amount of
Lordship,
return from the pensionary benefit if the same has not yet been recovered.
Lordship.
And what happened to the petitioner counsel? Nowhere there. He has not appeared thereafter.
Lordship, he has not appeared.
He has appeared on 29/7. Thereafter, nowhere to be seen. Okay, none appears on behalf of the petitioner on call. It's the Mutari, the learned counsel appearing on behalf of the Secondary Education Department. Apprised this court that the Joint Director of Secondary Education have issued a communication to the Inspector of School directing the latter to resubmit the pension proposal of the petitioner as per the objection raised by the Director of Pension. After verification in light of the government OM dated 27/1/2022. The said instruction is kept on record and marked with the letter X.
Lordship, what the petitioner has paid here is, he wants, in the light of Rafiq Masih, your Lordship, he wants it to be disposed of, your Lordship. Because to make verification, if he is not directly involved.
But he is also prayer is for releasing his pensionary and retirement benefits. That is there. List the matter again on how much time?
Lordship,
11 in May 24th.
20 Lord.
List the matter again on 24th of May, on which date the Learned Counsel for the Secondary Education Department shall apprise the further status as regards the petitioner's pension proposal.
18.
May I please your lordship?
Hmm.
The respondents
Today we
have
have filed the
affidavit in
On
opposition.
behalf of respondent number 2 and 3. It
You
was yet to
filed?
be the affidavit in opposition
You have filed?
today itself.
You have filed?
Yes. Let it be take with your record.
2 weeks time. I am taking 2 weeks time for region director lordship. Today they
Okay,
filed
Mr.
affidavit, I
F. U.
received.
Balbhuya, the Learned Counsel appearing on behalf of the petitioner seeks an accommodation of 2 weeks for the purpose of filing the reply to the affidavit in opposition so filed by the
Respondent
respondent
number 2 and 3, madam.
Huh?
2 and 3.
2 and 3. List the matter after 4 weeks.
19.
Yes.
In this case, I have challenged the order for letter my lord, case 30 my lord. whereby
This is a
refused-
matter of issuing notice on 15/2. Well,
My lord.
nothing has happened.
No affidavit has been filed. The respondent number 5 issued the impugned letter my lord. Whereby
What is this order you are explaining?
my lord, case 30 my lord, annex 6.
Page 30. What does it say?
So my lord, the fact is that the petitioner is the second wife of Mohammedan my lord. Mohammedan second wife my lord. Then refused to sanction as because my lord, the sanction permission of second marriage obtained as per conduct rule.
So this is no longer there. This judgment has already gone for a 6 by the full bench.
My lord, that issue has not been my lord, as because my lord, the first wife already died my lord in the year.
Oh, first wife
2015.
died.
Died my lord. Subsequently my lord claimed the second wife. As per my lord, rule 143 my lord. That's it.
First wife died.
Died in the year 2016.
Okay, what is your instruction?
We are the pension department. The AG would have the.
No, which is the department?
PWD and AG would be there.
PWD.
PWD.
PWD is difficult to find. The moment you threaten the appearance of the commissioner, then only they appear. Otherwise, they don't.
Impugn order by the AG. Impugn order passed by the AG, my lord. Whereby
Okay.
returned the
AG?
my lord.
Yes. You got instructions? Very well. Give it to me. PWD? No PWD. That is the problem with PWD. Heard Mr. K.R. Patgiri, the learned counsel appearing on behalf of the petitioner. Miss, you are appearing for? What's your name?
M. Malik on behalf of Ardhar.
No, Ardhar. Ardhar was here now. Where is he? He must have left. Your name?
M. Malik.
M. Ali.
Malik.
M. Malik appears on behalf of the Accountant General AE. None appears on behalf of the Public Works Department. That is the response number 146. None appears on behalf of the Finance Department. That is the respondent number 3 and 7. Mr. C.S. Hazarika appears for the respondent number 2. Ms. So-and-so, the learned counsel appearing on behalf of the respondent number 5. Placed on record a particular communication issued by the senior account officer, legal cell, wherein it has been mentioned that the PWD, the PWD, Public Works Department, till date had not resubmitted the family pension papers and the service book in compliance to the communication dated 14/6/2018. It has also been mentioned that the petitioner, that the Public Works Department have been again reminded on 2/11/2021. However, the said PWD department have not done anything. The copy of the communication instructions along with the copy of the reminder dated 2/11/2021 has been placed before this court by the learned counsel appearing for the Accountant General AE, which is kept on record and marked with the letter X. That the matter be listed again on 10th of May 2023, on which date the PWD department shall apprise, the learned counsel for the PWD department shall apprise this court as to why the family pension papers as well as the service books of the petitioner have not been forwarded as sought for by the Office of the Accountant General AE. List according.
20.
By order dated 9/12/2022,
Hmm.
and the respondent undertake to release the payment.
The court has requested the government for release of funds as supplementary demands has been rejected by the government in the court.
Yes, Lordship, in this matter, I request some time, Lordship. 1 week time may kindly be granted, Lordship. We have sent, although we have sent the proposal to the Housing and Urban Affairs Department, which is the parent department of the Assam Urban Water Supply and Sewerage Board. But till that, we have not received any communication from their end, Lordship. So may I pray for a week's time, Lordship?
You have sent it to?
Housing and Urban Affairs Department, Lordship.
Who appears? Why? They have sent a proposal, why we have not done it?
But the instruction, I had the opportunity of looking at from the case records, Your Lordship. It seems to have been given from accounts officer to the legal, to the registrar. That letter, if it is given to me, I'll obtain the necessary instruction from the department.
Heard Mr. Kyle, the learned counsel for the petition. Mr. R.M. Das appears on behalf of the Assam Urban Water Supply and Sewage Board, and Mr. C.S. Hazarika appears on behalf of the which department?
Lordship.
Each department?
Housing and Urban Affairs Department.
Housing and Urban Affairs Department. Mr. C.S. Hazarika submits that, no, Mr. R.M. Das submits that the proposal have already been sent to the state, Housing and Urban Affairs Department. But nothing has been forthcoming from the State Department. Mr. C.S. Hazarika, the Learned Counsel, submits that if a copy of the state communication is given, he shall take appropriate instructions from the department. Mr. R.M. Das, during the course of the hearing, has served a copy of the state communication to Mr. C.S. Hazarika, who list the matter again on 10th of May 2023 for instructions from the Learned Counsel appearing on behalf of the Housing and from the Learned Counsel for the appearing on behalf of the
21.
Lordship, we have filed a affidavit today.
Oh, this one.
My lord, they have filed affidavit, my lord. In affidavit, my lord, para two lordship, they have stated that they are willing to pay the regular scale from 8/9/2014, my lord.
Don't matter over.
No, Lordship.
It's my
In
lord
terms of the order that it's forthwith, in terms of the
He is competent to depose that in terms with the Honorable Court order deponent on specific received from the newly elected, we have begged to state that henceforth so and so is willing to give the regular scale of pay to each of the petitioner in terms with the order dated. And as regards the area salary, they may be given the liberty by resource to submit the individual representative addressing the managing and board would thereafter take such decision taking into account its financial exigence. That is the issue relating to areas of mutually agreed terms. Yes, madam.
My lord, regarding salary, my lord, may come to page number 58, my lord.
Of
I
what?
would like to point out, my lord, of writ petition, my lord.
Yes.
My lord, they have already approached this honorable court, my lord, for salary, my lord.
What?
My lord, may come to page number 58.
Make necessary state
And
except
relevant
for
portion is, my
payment of salary to the petitioners from January, March, and they may also be paid the correct salary which exercise shall be unspeaken by reform in a period of 3 months. Yes, then.
My lord, then against that order, also after that order, also they have not paid any salary to us, lordship. Therefore, we have filed contempt, my lord.
Then.
Contempt is also pending, my lord.
Huh?
Contempt is also pending.
So,
Lordship, this is the affidavit on oath, Lordship, saying that we'll pay it forthwith. And thereafter, this was the consensus on the last date, Lordship. And why we have referred to that order, because the regular scale of pay in terms of the order dated 8/9/2014. We have not said that we are paying, we defect from 8/9/2014.
But lordship, we are claiming from 8/9/2014.
No, here I say upon hearing the learned, this court deems that a statement made by Mr. Das, learned counsel for the court to the effect that the respondent henceforth would be giving the regular scale of pay to the petitioner, and there would be consideration of representation submitted as regards the area salary be put by way of an affidavit so that the court may take up the matter for further consideration. Then.
My lord, we are claiming for regular pay scale from 8/9/2014, my lord.
Very well. That is what has been accepted on the last occasion, that they will, as regards the salary.
Salary, we have stated that we are paying forthwith, Lordship, regular scale of pay. Regarding the earlier salary, the board will take a call, Lordship, the new board.
They don't have money. What is your entitlement to the salary prior to that?
Madam?
What is the your entitlement to the salary prior to 8/9/2004?
Prior to my lord, 8/9/2014.
Prior from now?
16,000.
Huh?
16,000.
What is your right to get that salary?
Because lordship, we are appointed in the year, my lord, 2014 itself, my lord.
Under?
My lord, as office assistant, my lord, and by the board, my lord.
Very well. Are you entitled to the ROP?
My,
You are entitled. How? Have they adopted the ROP?
No,
maybe.
Then
My lord,
we
2014 to till
we
date,
do
also.
one thing. We need to negate this particular affidavit. Not necessary. We dismiss your petition. What to do? You don't. You have to show your right.
My lord, after due advertisement, my lord, they have
On the
appealed.
last occasion, he gave the concession, taking into account that it is a new board. This is why we are going to take it. We are going to henceforth pay him the regular scale of pay. As regards the earlier one, you are to submit. That was agreed that you will submit your representation. They will consider.
and that was agreed on the last occasion, Lordship.
My lord, as the contem is pending, my lord, that's why I'm.
Huh?
As the contem is pending, my
The
lord. that's why I'm
contempt, the contempt was to be dismissed on that day itself.
No, no,
I didn't dismiss it on.
no, Lordship, that was a earlier writ petition pertaining to the different cause of action. That is that becomes infectious.
That will become infectious. Because this is on that day, that aspect also was brought
Yes.
about the pendency of the contempt.
Yes, Lordship.
So as to whether they'll have to have the resources, they have to have the finance, they don't have the finance for that. The government is not paying them. They can't run from their own. Howly,
No, Lordship.
Vishwanath-
Vishwanath Sareli.
see, Vishwanath Sareli is now going to become another subdivision.
Now converted to something.
See? Look at the state of affairs of them. Now they have been converted to another subdivision. Earlier they were a district. Now you're pressurizing them. Hello, they'll have it after vacation.
Lordship.
But next time, I'm telling you, they have given it. You have to show me your right to get the regular. From now. Forget about the earlier people. Now also. As to whether you are entitled to the ROP. Heard, Miss?
Yes, okay, my lord.
The learned counsel for the petitioner, Mr. T. Das, appears on behalf of the respondent number 3,
1, 3, and 4.
1, 3, and 4. T.S. Hazarika appears for the urban housing.
Director of Municipal.
Director of
Director of Municipal Municipal Administration. In pursuance to the order dated 23/3/2023, the respondent number 3 have filed an affidavit. Had filed an additional affidavit. Had filed an affidavit. The same is kept on record. The affidavit. Let the matter be again listed on (24th of May).
My lord, 28th of April, may I prefer date on 28th, my April.
28th of May.
April.
No. You are okay. We fixed it on 29th of May. 29th of. Rastani. Vikas. Both.
22.
Any urgent matters?
Stay order is already there, and not that much urgent.
Huh?
Not that much urgent for me. Stay is already there, my lord.
What?
The impugn order has already been stayed.
Stayed?
Yes.
Who?
By the protector. Like in this case, my lord, I have challenged the final show cause notice.
Shall continue till the next date. What is the interim order?
In this petition,
What
my
have you
lord,
challenged?
the final show cause notice on the ground that, my lord, is predetermined and is an empty formality. My lord. Your lordship will find the impugn order is at page 29 annex 5.
Final show cause notice?
Yes, my lord.
Why have you challenged that?
Because it is predetermined, my lord. because of three details.
Where is that final show cause notice?
29 annexure 5.
Annexure, page 29.
Yes, ma'am.
That the inquiry into the charges against you in connection have been complete. A copy on perusal of the you are given seminar for submission of representation, if any, against the referred findings on receipt in case of non. What is that?
Your Lordship, can you see the second? On perusal of finding, it is noticed that the charges of gross misconduct and indiscipline action are proved. Hence, you are liable for punishment. So already made up his mind, Miller, that I am guilty. Thereafter, I have been asked to submit representation. His mind was not open. Miller. He should be
Mr.
that should be
Rafiq.
open mind.
Today, the first matter I have allowed you to withdraw.
Yes.
As a last item of the day also, I don't want to dismiss your matter.
Yes, sir. Earlier also, I have challenged the same issue, my lord, and this honorable court has set aside the order, the second show cause notice.
How can you, this is a show cause notice being issued, you go reply to that and say that no case is made out, that is it. And then whatever decision they take, and thereafter you have to take the disciplinary action. You have a right, in view of the ECIL judgment, you have a right out there to say that, look here, this is not there, all these findings which are there, this is wrongly done. But are you not stalling out a proceedings of 2021?
There are 2-3 judgments of this court, Miller, on the same issue. Because
Let it be there.
on this sentence,
I am bound by the Constitution bench judgment in ECL.
yes,
The only scope out there is this was not there after the 42nd Amendment. It is because of the ECL judgment that this right has been there, saying that you have a right to show that you are not guilty. Not on the question of punishment. That aspect has been taken away by the 42nd Amendment.
yes, yes.
But the first aspect is still there, that you have a right to say that you see the inquiry report which has been given wrongly. And as such, I have been exonerated. If then the disciplinary action authority takes any decision, then you have a right of appeal. Why should this court forestall all these things now? You are still running in the service?
Yes, sir.
Very well. And because of a stay, will not dismiss it today.
Thank you, Lord.
Otherwise, you may say that today the first matter I had dealt with like this, and the last matter also happened.
The alpha and omega of the proceedings of today, Your Lord.
Huh?
The alpha and omega of today's proceedings would be like this.
Okay, I heard Mr. I. Rafiq, the learned counsel for the petitioner, and Mr. C.S. Hazarika appearing on behalf of the respondent. This is the matter of application.
Obligation.